into how much inquiry is the court going to allow or examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to what the immunity order means, what the consequences or potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of agree to it before we do it. And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, I mean, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor,
Suggestions?
Your Honor, when the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it because there is potential criminal exposure.
No, I know. I think you might have, I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I mean, I think he's probably entitled to counsel if he wants it to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself, whether he is currently represented by counsel or not, and or what his intention is if he is not.
Sure. I mean, yeah, I agree. I guess I can't find that out before he shows up here.
I can have someone who just bring him in.
Okay.
Where he is, so I can actually ask.
All right. I mean, yeah, if we can find him, and even, I mean, I don't care if he shows up by Zoom for me to ask those questions, you know? I mean, that's fine with me. All right, so if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to pre-recusal motion? I can't hear you. Y'all can think about that for a few minutes. Ms. Fields let me know that the 6/12 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting mailed out to y'all, emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachary? I think you said you had at least a good portion of that ready.
Yes, so counsel for Mr. Stillwell sent over a series of redactions that they like to see made, but we have objections to those, and so that is
Okay.
right here.
All right, that sounds good.
Would the court permit me to just step out?
Sure. Is Mr. Atkins going to take it from here while you're
No,
out?
I'm just asking him about Mr. Copeland and seeing if I can get him on the phone and get an answer to the court today.
Okay. All right, so the Zachary evidence, can somebody provide that to the court? Whatever we're going to be
Yes, Your Honor.
sorting through.
I'll send the transcript from this interview, Your Honor, and if the defense counsel objects, I can send what Mr. Shard sent us so the court knows what
What we're walking through.
Yes, Your Honor.
That'd be great.
Because it's broken down by numbers.
Okay, good.
And does the court already have the transcript?
I don't. No, but Mr. Atkins just said he'll send those.
And Your Honor, with respect to the transcript, they are uncorrected. There may be corrections that I make and then send to the defense.
Okay. Yeah, and maybe pick up your mic. And y'all, I think I told y'all yesterday, I'm trying to get longer stems for these, but
I didn't even turn my mic on, so I didn't even get through step one yet. So it's now on and I am holding it. Mr. Atkins, Miss Love, Mr. Zachary's statement, his statement that I did not review yet, or I've reviewed it, but I haven't given you the total redactions. Are you planning on playing if allowed, the part where he talks to the AT feds about the guns?
It's possible, and there were two statements.
you should talk into the mic too, so everybody can hear you.
I keep remembering how loud I am. It is possible, and there were two. I think yesterday when I spoke, I was expecting one more from you. There are two, the 2015, the August 2015 one, and then I think it's the March 2017 one. And we have your redaction request for the the August 2017 one. So do you mean for both of those? Or are you just asking about the March 2017 one?
The transcript doesn't, I don't believe, say what date it was, but the time he talked to the federal agents after speaking to Investigator Gaither.
And so when you say put it in, I wouldn't, outside of impeaching him, I wouldn't have a need to put in all of that. I would be asking the witness on the stand about that. So I can, with the court's permission, I can break away and talk to you about exactly what it is that you're concerned about.
Okay, well, I'm gonna send over my proposed redactions for the statement to Investigator Gaither with the understanding that I didn't list out any redactions for the discussion with the federal agents.
Okay. So you're sitting over the 2015 one? And then,
Yes.
okay.
All right, so there's one that has been done completely, the proposed redactions, right? So we'll just start on that one, and then I'm sure we'll have a morning break at some point. Y'all can maybe, if you need to huddle more on the another one, then that's fine.
Thank you.
transcripts of Zachary's potential, I mean, I guess it's statements over at Ms. Persfield or?
Yes, Your Honor, and I was gonna also inquire, we have an extra physical copy of the transcript, if that
Right.
works for the board.
Sure.
And then I will just email the redaction chart that we discussed.
Okay. Waiting on that to come through and then we'll get started. All right, do you want to hand up the
Yes, Your Honor.
hard copy of the transcript? Because I don't have the electronic one quite yet, but I'm sure it'll come through at some point, but we can go ahead and get started with the hard copy. Wow, that's a lot.
The court can keep, but this teal colored one is gonna be what we're gonna discuss first.
Okay.
The red may come up later with the next.
Put the red to the side right now.
That's perfect, Your Honor.
Thank you. ready with the first one on, that's, I guess, page 11, lines 10 through 12. Is that what that means? Or is that a time stamp?
Your Honor, that is correct. There was a couple Mr. Short had that, for the most part, I could follow. So if there's a
Okay.
discrepancy, I may ask Mr. Short specifically what
Okay.
line he
All right.
wanted, but I believe for the first one, that is correct.
All right. And is this mine to keep, this teal one?
Yes, Your Honor.
I can write all over it if I want
You
to.
can highlight it, write it.
Okay. All right. So, Mr. Sharp, the document that I'm looking at that says Quindarius proper session proposed edits, and it's all numbered 1 through whatever. Okay, so where am I supposed to be looking with regard to that first one? Because it's a lot of different numbers. I'm not sure what they all mean. Okay. I assume 11, 10 through 12 means page 11, lines 10 through 12, but then it has 10 again, which I don't know what that 10 is, and then
It should be when it ends. So it would be like 10, I'm pulling up my document.
okay. It is, I'm sorry. Go ahead with what?
So that first one would be page 11, line 10 through page 12, line 10.
Okay, that makes more sense. Gotcha. All right. And is one of the objections to all of this going to be these aren't proper under the co-conspirator exception?
Well, not everything that he says in these sessions is based on what arguably a co-conspirator said to him. Some of it may be, so some objections may be it's improper character evidence, it's irrelevant, things of that nature.
right.
But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that I don't know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that is probably something that we're going to need to wade through at some point.
Okay. All right, so the very first one is, I'm about to tell you something, and I've just said I wasn't there.
That's in page 11, line 10.
Right. So it's obviously hearsay, so what's our exception?
You're on a part of it. When he's saying that he's at Crucial,
No, he's saying I wasn't at Crucial.
when he's saying I was not at Crucial.
Right.
And he can't speak about being at Crucial.
Mm-hmm.
I don't have any objection to him speaking about or trying to speak about being at Crucial. I don't have any objection to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them, I haven't synced them up with my transcript in my
Okay.
recording. So, because I've read the transcript and listened to it so many times,
Okay.
I've gone through it with that knowledge.
Okay.
I haven't synced it up. I
Okay.
don't have any objections to it. Page 11, line 10.
All right, so that's out by agreement. All right, so that one's out by agreement. Do you want to, is it, if I gave you 30 minutes, could you decide which ones you agree to? Okay. Sarah, something else anybody needs to take up before we take our morning break and let Miss Love do that? All right. Anybody else? Nobody? Okay. All right. We're just gonna take our little morning break early. So we'll be back at 10:30. Agreement on anything?
Judge, I have just been reviewing Mr. Sharp's proposed redactions, and there are some that I agree to.
Okay,
Not a whole lot, but we've already given the court the first one. Does the court have a copy of his redaction? I can give the court.
yeah, the proposed redaction, yes.
Yes. Okay, so looking at Mr. Sharp's chart, number one, we've already discussed. Number 17 is the next one.
All right, and that's agreed to?
Yes, I don't have any problem with that. That's the discussion of the search of defendant Williams' home, revealing a gun, and the gun and the contents of that search were suppressed, so that should
Okay.
not come in.
All right.
As well as number 19, which is on page 73 of the transcript.
All right,
That is, just to call it out, speculation.
okay,
Specifically, it's 67, line 15 through 19. No, I'm sorry. Mr. Sharp has a description that is different than the lines that are listed. So 70, so on page 73,
mm-hmm,
I don't have any objection to lines 10. He has it right, lines 10 through 13, no objection.
Could you just give me the number of the section when you make the
17.
So 17 and 19, I also don't have any objection to. 23, I don't have any objection to.
Okay.
Could you clarify what the first one you did not have an objection to?
The first one that I did not have an objection to was number 1. And number 1, if you have, you already have the redactions? Okay, so it was Mr. Zachary, after saying he wasn't at Club Crucial, he talks about what happened at Club Crucial. And Your Honor, I will say that as it stands, I'm not trying to get that in. I
Okay.
don't know if something else changes, but right now we're not, I agree that it should come out.
Okay. All right, so we had gone through 23.
24, 25, 26, I don't agree with. Going to 27, it is 9211. Keep out. All the way through 9422. Mm-hmm. 9211 through 9422. That's what I've gotten to agree to. If the court permits me to further review the rest of them, because some of them I was looking and I don't agree to, I'm ready to argue those, or I can.
Let's do that right now, and then
All
over the lunch break, you can go through the ones you hadn't hit yet and see whether there's agreement on any of those.
Did
Okay?
you- Did the state agree to 27 or no?
It's,
No.
no, sounds like so far just 1, 17, 19, and 23. Okay. All right, so I guess that means 2 through 16, we need to take up.
Yes.
Okay.
And Your Honor, will we just follow the same pattern we did last time where the defense tells what their objection is?
Yeah, so I mean, the objections are essentially on the proposed redaction, so I guess the objections generally speculation about why they shot up the house.
So page 13, line 16 starts at Dennis talking with the witness about the house getting shot up, and this is following, I think you have to go back a little bit further to page 12 to get better context. In that conversation, the witness is talking with Demekion Garlington about people that call him that night, starting on page 12, line 14. And Quindarius Zachary is talking about his girlfriend telling him what's going on.
Right. Yeah, so it starts at 13, line 16. He doesn't have objection to him saying, hey, this house got shut up. It's why the house got shut up, which the objection's speculation.
So my argument, assuming I established the proper foundation, is that with Quindarius Zachary saying that Trevante was helping D-Fight. He's talking about Demekion Garlington.
Right, so what would his basis of knowledge be? You would need to establish that he's got a legitimate basis to know that.
That's the point that I'm making. Like, without doing it, I wouldn't, if
Okay.
I were not able to do it, I wouldn't proffer it or even try to play
Okay,
it.
and so you think you can?
Yes, that's the point. Especially, Your Honor, when we're talking about, he goes all the way through to line 2.
Right, 14, line 2.
Okay, I was looking at line 14.
And
Unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
okay, so how about this? Right now, it's out on the,
Okay.
granted as to speculation.
Okay.
And if you establish it,
Okay.
then that'll be a different story.
That'll work. Okay, so the next one being page 25. So 25, page 25, line 9 through 25:12 is a direct statement from the witness about an incident that's listed as an overt act on the indictment.
Okay,
And what they were doing, it's an admission.
all right.
It's an admission against it.
All right, so what's our objection there, Mr. Short?
My objection is drug use. And the character that's associated with that and the statement, they didn't, where is it? They really didn't care. That's speculation about someone else's mind state, or state of mind. The reality is, within this context is a story about that Mr. Zachary gives, that he describes my client, as well as others, shooting up houses. And I'm not, of course, I don't want that to be admitted, but that's a fight for another day. But I'm not objecting to that on any of these bases, but I am objecting. So I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is.
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of that.
All right, Ms. Love.
So Judge, my argument right now until I speak to him is that he is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does, that as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachary, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him not getting out of the car. We'd argue that it's intrinsic. It could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think I'm going to overrule it as to character. And if you can establish that he actually knew they were on Xanax and high, that's fine. On they really didn't care part, are you maintaining that part should come in?
Yes.
Because his observation is that
they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that, wait, you.
right. What's the motive? The motive's just they were high.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I will let you use that part. So overruled as to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
So that is number. So the next one is further down. Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachary responds, the request is to take out 17 through 25 all the way.
Yeah, I think just
I'm
17
sorry,
through
25
17 through 20.
Yes, I'm sorry. So 17 through 20,
Right.
he's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish that he knew that's what they were planning to do, and it's not.
And he doesn't say they, he says that
Oh,
we
he's-
were going to kill one of the.
Oh, I'm sorry. Actually, I maybe need to put on my glasses. Thought that said they were, but that we were, yes.
So, Your Honor, let me just back up. So this is an incident where houses were shot up. Mr. Zachary was charged, and in this proffer session, he's given testimony to try to get himself a deal. And I understand that's subject for cross-examination. My client was never charged.
Okay.
Mr. Zachary is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention?
Mm-hmm.
Now, it strikes me that Mr. Zachary can speak to his own intention, unless he says Mr. Stillwell was there and this is what Mr. Stillwell said or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachary, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachary, I don't think he's authorized to speak to what anyone else's plan was or intention was. And when he starts saying, and it's not his fault because
Of the way
Mr.
it's
Bailey
asked.
inartfully asked what was y'all's intention, and that prompted him to speak for other people.
Well, I understand, and it may very well be that you can establish that they all had a joint intention because they had some sort of talk about it beforehand, or.
And they actually he reveals earlier in the interview that they do discuss it.
All
that they
right,
are
so
having
where's
a
that?
So up. On line 4, he says, because he said we're not gonna shoot, how to leave that to them. So on line 2, investigator Dennis asks, why does Moontoon, and that isn't actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachary said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachary is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had.
Well, Your Honor, he's
Line 9.
talking about what Moontoon said. Moontoon's not even here. My client is not Moontoon. And so I don't find respectfully what Ms. Love said to really address the issue.
All right, so where is it that your client what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car according to Mr. Zachary. But what Ms. Love talked about is Moontoon telling Mr. Zachary to not get out the car, saying, we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish that that through Mr. Zachary, that my client indicated what the intent was, what the plan was, that's not in this transcript. That's going to come across through live testimony, which would render these prior statements, out-of-court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Judge, I thought that the whole purpose of this exercise was assuming that
Well,
they
it
don't.
is. It
Okay.
is. Okay, so assuming you need to use it as a prior inconsistent. statement. or-
Yes, and in response to Mr. Sharp, Mr. Zachary is talking about his own intent and his understanding of what the conspiracy was. Arguably, this is a conspiratorial act of going out to shoot. We were going to kill one of the boys. So he does not, I don't think that it's improper for him to be able to talk about what the intentions of the group that he is acting as a part of were, as shown by their actions and their words throughout the course of the conspiracy itself.
But if it's just, if his statement is just based on assumptions he's making through the actions of others, then the jurors are in a similar place as Mr. Zachary to make that, to draw that conclusion.
But Mr.
So
Zachary,
I don't understand why Mr. Zachary, his conclusion about what my client's intent was would be particularly helpful or relevant to anything unless my client articulated it to him. And from my understanding of what Mr. Zachary's saying is he gets a call from his girlfriend Summer. Mr. Garlington and Mr. Sledge leave the club. Mr. Zachary doesn't know, according to his story, he doesn't know how Mr. Stillwell gets in the car because he wasn't at the club. And then they pick up Zachary last. And Zachary does not describe any conversation in the car on the way to these houses or anything like that. He doesn't give any context about communication. He's just kind of like, I got in the car and this is where we went.
so Judge, this is also the third interview that Mr. Zachary gave. He gave one earlier in 2015. This one occurred in 2017. So there are statements about this same incident in the 2015 interview as well. So we haven't gone through that one, but I could cross-reference that as well and provide those cross-references to the court. But the reality is that an assertion by a co-conspirator, if everyone is acting towards the same goal and people are getting shot up, houses are getting shot up, and
With assault rifles that are in the car.
right.
Yeah, I'm gonna overrule that. All right,
25.
28, line 17.
The
No.
font is a little small. I'm just having,
I'm sorry?
I need the court's glasses. I'm
Yeah,
just trying to
28,
get down.
line 1 through 3.
And with this one, Your Honor, I'm not trying to mislead anyone. If one of my colleagues tells me I'm wrong, then I'm wrong. My recollection, there has been no testimony about someone being shot in these houses.
Okay.
If I'm wrong about that, feel free to correct in this instance. The
So
shooting at the
this
houses.
one, we have given the list of 30 witnesses, and one of the first witnesses after Mr. Zachary is the young lady who lives at this house and her sister
Okay.
getting shot at. So there hasn't been,
Did somebody get shot at this house?
yes.
And that evidence will come in through this
The-
other, what's the name of that witness?
Miss Bell and her sister Cecilia.
So they're coming to testify?
I see him on the witness list.
You don't see them?
Yeah, I do. I see Denise Bell. I don't know what the other person's name is. So you intend to call somebody who says somebody at this house got shot?
Yes.
Okay, so then that is all right. All right, number 6. Proffer of proposed edits, record of part of an exhibit to today's proceedings. So In the event of an eventual review, whomever is reviewing it will know what we're talking about when we
Okay.
say on to number 6.
Can we make, you don't want us to use the one we're writing on, you want to make
Yeah,
it,
I mean, just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line you can go back up as far as line 7, but you'll see that there's context. You want me to pause?
No.
Okay, you can see that there's context. Mr. Zachary is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachary doesn't correct him or doesn't say anything about it, I would argue it just goes to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take
I
it out.
don't,
Strike it. Granted.
you're, okay. Out.
All right. I'm just writing August 6th, 2024, Courts Exhibit 1 as to this 3-page
Yes, Your Honor.
proposed reductions. Okay.
So
All right.
the number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachary is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Moontoon, Demikian is in the back with you and Shannon is in front, and then and then Mr. Zachary says they were in another car, yeah. And they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindaria Zachary about activities that YSL and Rivals are sort of involved in. Mr. Dennis talks about how they thought it was Kale, and Mr. Zachary says, no, he corrects them, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachary later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count 1 in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying we thought y'all did it, but
No, line 17 where he says they tried to say that we did it. on page 33.
Oh, it's back on page 35. I'm sorry. Okay. Okay. And so this would be to establish,
The existence of the enterprise, the gang, and the fact that there is an opposition in a they and a we.
all right, Mr.
So,
Sharp?
I mean, that's not factually accurate.
Okay.
On this.
Pull your mic towards you, if you don't mind.
On this
It
alleged.
moves, so you can just move it up on your desk, maybe, I don't know.
with
I
this-
know, they're all annoying, they get in the way.
With this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, as being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm
but
not sure I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay,
This is a gentleman who, you know, has not, there's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't have, I mean, I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachary saying Trevante Turner was part of this mission that he's claiming
mhm.
existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purposes of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here, this incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. You know, that he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about
So-
that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides at January 27 of 2015 incident 150262801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
But
an
that's-
associate of YSL and a member of YSL aren't the same thing.
They aren't, but I'm not asserting one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it, Quindarius Zachary, when we charge the gang act, associate or member, it doesn't matter. Associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, He's not just talking about a random group of men. He's talking about them as a group that operates as YSL is the argument that I would make.
Well,
Who's the they here?
The person,
Go ahead.
she does.
so
All right, let me,
so if gang is the gang that
so
they're
is that the they here? This is the
associates
part of the gang that
yes.
there's the alleged beef back and forth and the
Yes.
series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They, they tried to say we did it. I mean, false accusations by an unnamed group about something that the declarant, in this case, Mr. Zachary, is actually saying they were wrong about. How's that admissible to anything? And if that's the key section, that's inadmissible of itself in itself. But I think this whole section is just wholly irrelevant and it confuses the issues.
And if the court goes on further down,
Mm-hmm.
and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell Kel, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say. Is what Quindarius Zachary says. He's not pushing back against the notion that they would be laying in watch for Shell Kel. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and of a group that he belongs to.
All right. So,
He's literally saying, no, that didn't happen.
right. But she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL, and that is certainly relevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
And if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachary, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you
Right.
and whomever were involved in this shooting with the, whatever it is.
So unless, right, I understand fully. Like,
Then
in
he
other
says
words,
something different. You're like,
don't try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right, moving on.
Number 8 being page 36, lines 1 through 30.
I'm sorry, I haven't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue. But I can concede that and say that there's really not, I can let that one go. I
Alrighty.
can stipulate to that.
Okay.
I just like it.
And, Your Honor,
And that-
I think I may have made an error on that. 36, 1 to 24 is certainly about that. I'm not certain 37, 8 to 18 is about that same thing.
Okay.
I thought we were just doing the 1 through 24 first.
Yeah, all right. Well, I mean, he's got it all as number 8. So,
Okay.
all right. So agreed that 36, that part is out. So turn into 37, 8 through 18.
So in 37, 8 to 18, as I understand it, they're trying to identify Tay, and they're showing picture of Tay with a car, and they're saying, is that the car? And then Investigator Underwood and Dennis and Zachary are agreeing, no, that's not the car. That's the car that got shot up by another person named Kel. It's just about Tay's other car that was not involved in the April 28th, 2015 shooting up houses being shot up. It's just
Okay.
talk about another car being shot.
All right. Is
Has
that
nothing to do-
relevant?
So, Judge, in context 37, Mr. Sharp's objection goes all the way into page 38, unless I'm reading it wrong.
No, it's 37, 8 to 18, right?
It's-
Correct.
Okay. For now, Judge, I can stipulate to that. I don't see any reason to keep that part in right now.
All right. So that is also out by agreement.
And Your Honor, should anything, and I don't anticipate it, but should anything come up that causes me to ask the court, hey, there's something I agreed to that I need to get in now because.
Let's
this
not wait
happened,
until the last minute to do it. Okay.
It would only be by virtue of something happening on the stand. but-
Okay. I mean, can you imagine a scenario why it suddenly becomes relevant that some other car that,
It's not the car being shot up, it's Mr. Zachary giving the description of the individuals and his knowledge of certain individuals.
Tay?
Mhm. And
Okay.
K-
So
the
that's
boy called
lines
KL.
3 and 4. Is that Tay? Yeah.
And 16, where he's talking about the other boy called Kale. Those sort of instances. I don't foresee them being necessary, but I didn't want to not say to the court, hey, this might come up.
Okay. Well, so maybe if there's some issue as to who Kel is. Okay.
And then I think that the next one on number 8 is all of page 38.
Yeah.
It's 38, line 8 to 39. line 11.
Hold on. 38. Line 8, okay, through 39, 11,
Really to 39. It's
through 39, line 1?
the end of 39.
Okay.
Oh,
It's two different incidents. It's a discussion about people saying on the street. Again, I'm just trying to clean up this transcript. It's just going to be confusing to people. I don't care if all sorts of bad things come up in against about Tay one way or another.
Right.
But I'm just trying to limit confusion that the
Right.
jurors would have. And they're talking about people on the street saying that Tay shot up Rich Homie Kwan's dad's barber shop. Rich Homie Kwan's
I have no
father
objection
is a
to-
barber and runs a barber shop.
All right, she may
Oh.
not, she may agree.
I have no objection to 8 through with the clarification that he made, because I thought it was the whole page.
Okay.
So I have no objection to 8 through 24
Okay,
of
so,
page 38.
all right.
And then on 39, uh, 30 to 39:19, 1 through
39.
19.
39, 1.
39, 9 through 19, or
1
just
through
all
19.
one, okay.
I have no objection to 1 through 13, where he stops at,
Okay, so 13 is the end of the Rich Homie Kwan
right,
barber shop. And then they
yes.
start talking about Tay shot Kel.
And
I don't. Again, I don't represent Tay. Tay's not associated. So, but it's just I just think it would be
Alright.
confusing.
Why is it?
Tay is associated, that's what we were just talking about, Tay being Trevante.
Right, who's dead and not on trial here, right?
That's true, unfortunately.
Okay, so is it relevant?
In it,
I mean, I would assume you want a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
yes, it goes over into page 40. There's a video that we're gonna have about with Quindarius Zachary, Antonio Sledge, I think Demekion Garlington, and they're saying they're talking to Shell Kell, who is Ifgang, and I think that they have a gun. That's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things.
Mm-hmm.
And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that we're talking about one associate or member of YSL, Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're gonna introduce anyway. So I don't know why this would not.
I don't know or understand the nexus between Mr. Sledge threatening Kel on social media over a common girlfriend and Tay shooting Kel. I mean, I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, they'll take it out.
We'll take out. So it's gonna be 15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 42:15. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what now?
To number 9 on my list is the continued discussion about the beef between Kel and Trevante, and they start out with Trevante shooting Kel, and then they talk about how Kel allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachary
We don't.
saying his understanding was that Kel shot up his girlfriend Trevia's house.
right. Hang on. Ms.
So-
Liv.
In as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin Watts shooting up Entrevia's house, that part is correct because Entrevia Smith relayed to police when she gave them that video that Kelvin Watts was in the house with her. So in as much as Quindarius Zachary is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that would be relevant. It wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that at this time, we're going to talk to him. We've noticed the defense about our intent to talk about when Entrevia Smith's house got shot up. It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to introduce evidence of.
If they bring up shooting of Trevia's house, that's one thing, and that's, it may or may not be relevant. But my issue, and I don't agree with the state's characterization about Mr. Zachary lying about it. What we're dealing with here is not Mr. Zachary lying. Mr. Zachary wasn't at Trevia Smith's house. Mr. Zachary was not shooting at Trevia Smith's house or being shot at Miss Smith's house, Trevia Smith's house. Mr. Zachary is passing on rumors that he's heard through the grapevine about who did what, and the police are saying, well, we don't believe that's accurate because we believe that Shelkel was in the house. So how could he shoot up the house? So it's whether it's a relevant topic or not, it's all based on hearsay that Mr. Zachary has no firsthand knowledge of.
Excuse, Judge, I just point the court's attention to the first line of page 41. And I'd also point out that Mr. Zachary was in that video that Entrevia gave over to the police after her house got shot up. He was in the video along with Antonio Sledge, where they were threatening Kelvin Watts.
All right. Let me ask you this. Could you take a closer look at the rest of 39 through 42 and maybe sort out what part of that you think, if he doesn't testify as you think he will, you would use to impeach him on a relevant issue? And then maybe get back to us on this one?
Yes.
Okay. Because I mean, I kind of hear you saying, even you think not all of it is anything you would want or need. Okay.
And that's all the way through 42.
All right. So.
So the next one is number 10 is 42. Line 17 through 44, line 6. So when the objection is lack of personal knowledge, I am laboring under the assumption that Mr. Sharp's belief is that Mr. Zachary lacks personal knowledge. I would just ask that the court allow it, because it's all opposition actions towards one another. Shell Kell shot up the gambling house. On McDonald Boulevard, Dennis asks on page 43, line 1, that's when Thug's car got shot, right? I believe, if we haven't already, I believe that we have we've touched on that there was a shooting where his car got shot. But it may have been with Kenneth Copeland and some of the stuff that we have to redo.
Right.
But Mr. Zachary is saying, yeah, shot up Thug's car. Thug wasn't studying it. All of that information, maybe not like that, but that information we anticipate bringing out. So to the extent that Mr. Sharp objects and has as his basis lack of personal knowledge, I would just ask that the court find that it's admissible subject to the proper foundation being laid for it.
I'm okay. That seems reasonable if you can lay the foundation.
Okay.
Yes.
Okay. Okay. After consulting with others, we're going to withdraw our
Okay.
objection.
Okay.
All right. All right.
So I'm gonna take that out.
All right. Number 11.
45.
That should,
15.
number 11 should be 46, line
Okay.
15.
Okay.
46, 15 through 16.
Yes. Well, maybe I'm wrong. I'm wrong. It was supposed to be 45. I'm sorry. They're all talking about an unrelated, they're talking about a girl named Clenethia Rant. And then Mr. Zachary just says she's dead. And then they talk about the circumstances of her
Okay.
murder.
I don't have. All
right, that- she agrees.
Coming out. Mm-mm.
Okay.
What's her name?
So
That's 45, 15 through 46,
Yeah.
16. I agree.
Not
Okay,
number 11?
let me interrupt y'all a minute. I have word that Mr. Copeland is here and available right now, so why don't we pause what we're doing with this and have him in, see if he has an attorney, see if he wants an attorney. We don't yet have anything put together that I'm going to advise him of, but
I'm good with that.
we could get through a little bit more of this, tell him to hold tight, take a lunch break where y'all can come up with something. But I could at least find out about the attorney issue right now.
I think that's
Okay. All right, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters.
Huh?
I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know one to testify.
Okay, the first, well, right, want to is maybe the wrong term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know
I
whether.
was saying, I was talking to Melanie, but
Melnick?
yes,
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay, does anybody know whether that actually occurred?
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was standing and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was.
There was
but-
nothing about Mr. Melnick to my knowledge.
Okay, maybe we,
There was, Miss Bumpus actually said yesterday, I believe during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his, he
well,
could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melanie off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify,
Huh?
so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial, but I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you. So, I don't know who Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena, then you show me what authority
Yes, Your Honor.
lets you believe that. Okay.
Your
All
Honor,
right. Yeah.
One thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday.
Mhm.
She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said,
No, what he said was, if you plead the fifth, I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
yes, Your Honor.
All right. Okay, so let's get a few more minutes in of this before we break, because it's not even noon yet, and we were making some progress, which is good. All right, so we were on number 12.
I'm gonna let it keep playing, but I made this public because I wanted everybody to make sure we watched Woody come in. So Woody's going to be testifying or getting back on the stand a little later. That's gonna be good. But if you're just joining, they have basically been talking about the witness who is going to come after Woody. At least right now, his name is Quindarius Zachary, aka QZ, and they are talking about based off of the testimony that it's all theoretical, but when he testifies, what would be admissible. So they are going pretty much line by line through his statements to determine what would be admissible and what would not. So that is where they are. That's what the judge just said. Let's keep going. So that's what they're covering. It's not all that interesting, but the Woody part for sure was. But I'll let it keep playing.
Investigators, but it involved more than one member of YSL, more than one alleged member of YSL. Mr. Bloody J, who is a member of If Gang, was on the other side of the fight from YSL, and other people who are in the courtroom now participated in that with them. So Mr. Zachary's rendition of what happened, that we would argue it's Mr. Zachary's knowledge of and participation in this gang is what allows him to be able to tell this to Detective Dennis. Mr. Sharp's assertion, it does not appear that he was there, I don't think is a ground to exclude it, assuming that the court is satisfied with the foundation that the state lays for Mr. Zachary's
Being
ability
a
to
co-conspirator.
Yes, we would argue that it's admissible. It's
So do you know whether he was there or not?
so
So let me ask Mr. Sharp, is the basis for you saying you don't think he was there that no on line 23 when is that the basis of it?
What page, line 23?
47, line 23? Because I don't think that no is actually an answer
Oh,
to.
no, No,
Okay.
it's not based on that.
Okay.
I
You have no
actually
reason
do
to
not
believe.
know.
Okay,
I actually do not know
Okay.
he was there, and I haven't heard anyone talk about him being there.
okay. Do we
And
know whether
and
he
this
was
is-
there?
Page 48, line 5. Start at line.
Oh, so we went back there. Yeah.
Okay,
Okay.
if he was in fact there, then.
And
I
then
withdraw.
somewhere else, he says, would he, okay, all right, well then, you'll withdraw that objection?
If he was there, then yes.
Okay. So that number 12 is withdrawn. All right, number 13.
My understanding is this is page 54, line 18, through page 55, line 11.
Yeah, let's take that up first.
So the state has no objection to page 54, lines 18 through 22, where investigator Dennis says, who they say killed him, meaning Donovan Thomas. Zachary repeats the question.
Going to chime in again just very quickly to say what's happening is they're going over police statements that Quindarius Zachary or statements Quindarius Zachary gave to police during interviews. So similar to Woody, where he was at the police station and he gave some interviews. They are going over the statements that the witness after Woody, Quindarius Zachary, gave. And so the point that the defense has raised this whole time is that much of what these people have said to the police have been hearsay statements. They've been telling police snitching, quote unquote, about things that they actually did not witness themselves. And so that is what the defense, many of their argument is that they weren't there. How can you get this statement in? And so, of course, she's saying, well, it should be in because of X, Y, and Z. So she gives her different reasons. So that is what the judge is kind of weighing. Should these statements, parts of these statements be allowed in, or are they truly hearsay?
When he says, they say Woody and them, I don't know for a fact.
Mm-hmm.
If somebody argued that that's an inconsistent statement that should come in, I'm not objecting to it coming out because it was a lie, is irrelevant, but I'm not objecting to it coming out.
Okay.
So, Your Honor, we got a lot of moving parts here. Because eventually, I agree with Ms. Love. Eventually in this statement, Mr. Zachary claims that Mr. Kendrick told him that they killed Nutt and Mr. Stillwell told him that they killed Mr. Thomas.
Okay.
So I anticipate, because I was doing this for Mr. Stillwell, but I anticipate other counsel in this courtroom arguing that are affected by this, arguing that this is spilling the beans and it's not a statement by a co-conspirator and therefore not admissible.
Which part are we talking about?
Okay.
I think,
Okay. So, right. Okay.
okay.
So, if I guess I'll rewind. I will say that if there is testimony, either through direct testimony or cross-examine or impeachment,
Mhm.
that my client said something to Mr. Zachary, or that Mr. Kendrick said something to Mr. Zachary, then I would want to get that in.
18 through 22.
Right, because it would be inconsistent with the claims he says later on. Here he's saying, well, they're saying Woody and other people,
All right,
but
I
then
don't know.
later on he says, my client directly said this.
All right,
So if that comes in, I'd want to use that for impeachment.
I'd have to know who the they is here. Right, before that could be, if the they is Mr. Kendrick or Mr. Stillwell, yes. But if the they is some random amorphous gossip rag.
Well,
No.
it would be relevant because if he's telling the truth, okay, assuming he's telling the truth.
Oh, I see
He
who you,
is
I see what
holding-
you mean.
yeah.
If he's already said, or he will later say.
He's going to say that well, he already said in a different statement, and later in this statement, he's going to say that my client told him
Okay,
at night. And if he's holding that information, then him answering, they saying Wooby and them, I don't know.
all right, I still need to find out who the they is then, because the question posed by the investigator is who they say killed him,
I think.
right?
ask
So,
Who the streets are saying.
okay, well then, for Mr. Zachary to say, here's what the street is saying, is not inconsistent with, but I actually know because the perpetrator told me it's the perpetrator. So that would not be in this 18 through 22 would not be inconsistent to a statement by Zachary that Mr. Kendrick and or Mr. Stillwell told me personally that they're the ones that did it. You see what I mean?
I see what you mean. I would argue that that would be the time a reasonable person would say, who they say did it. Well, if my client had said he did it, say, well, I don't even need to tell you who they.
All right, well, I would reject that argument. So that's out. All right, so next. Is what, 20, page 54, line 23 through 5511. Is that all going to be the same
That is all.
chunk of whatever? Okay.
So we're starting at page 57, line 22.
No, 54. Because all we dealt with was 54, 18 through 22. It goes all the way through 55, 11. So, okay, you was with them at the condo afterwards. I was there. I mean, that,
All of that, we would object to it being redacted out. All of this is, Mr. Copeland talking about.
okay, so, all right. The,
Not Mr. Copeland, Mr. Zachary, my apologies. So I don't know how.
okay, so now I'm seeing Mr. Shard as I read on further. He's going back to the, well, that's what they say. I don't know for a fact.
Right.
I see what you, I mean, I hadn't read that part before. Who did they say? God, I don't even know if we're talking about the street here because you was with them at the condo afterwards. I was there, but shoot. That what they say? I don't know for a fact.
Right.
I'm saying, who did they say killed him? He may at this point mean, who did they, the people you are at the condo with, say? So can anybody actually point me to who the they is? If I flip back far enough?
In this particular interview, no, not as it relates to.
Oh, good
this
Lord.
statement right here. Because it's one of those.
It's all over the place.
No, it's, as it relates to the way that Dennis is talking to Zachary,
Yeah.
he means it just like if I were to just pop up and say, who did they say did it? There's no they identified.
Is there a video of this?
Yeah.
All right, I may need to watch the video of this part because maybe the inflection will let me know whether he means, let me watch the video on this. Can y'all send me that and then give me a timestamp for this part? Let me revisit that whole thing, including the 18 through 22 part.
If you send, I don't know if you have the times marked, but if you send the video that shows Mr. Zachary's face kind of zoomed in, I think it's MP4 video. I think it's right around 27 minutes, 30 seconds.
27 minutes, 30 seconds.
I
Okay.
believe so.
Thank you.
Per my notes.
Okay, thanks.
Are we gonna move, to the next one or just?
Yeah, no, I'll take a look at that offline unless y'all got it queued up right now. I'll take a look at that offline if y'all will send me that video. So yeah, if 5722 through 23 is a separate kind of issue, we can move on to that one. All right,
I have 3 digits. I know it's meant to be a typo. Probably, is it just 5722 to 5723? It has 223.
I think so. Your objection, Mr. Shart, here is 57 lines 22 and 23.
I'm going to withdraw that.
Okay. So that one is not objected to. All right. Moving on to number 14, which is page 60, line 19 through 61, line 20.
So, Your Honor, this is.
I'm going to withdraw that one as well.
All right. Okay, then our next item is on page 65, lines 8 through 20.
We're on number 15.
Yes.
It's, and my objection to this is just incorrect rendition of the law, explaining, Investigator Dennis is explaining to Quindarius Zachary why he's guilty by association.
Yeah, yeah, and I suspect he was not offering that as here's what the law is. He was offering that as here's what we law enforcement consider you to be, but I can understand that. You wanna agree to that, Ms. Love?
Judge, is the court will give me, my counsel is sitting here whispering in my ear, the court will give me 1 second.
To get there and consider it, yes, I will give you a second to do that.
I'm hearing you, court.
We'll see. All right, give you about 10 more seconds to make your decision. Then I'm just gonna make my ruling.
I don't object to 65-8 through 65-20 coming out.
All right. So that is out by agreement.
And Your Honor,
Yes.
yeah, I don't have any objection. I don't have any problem. all of number 15, and then 16 starts at 366. Line 12 through 66, line 18 is what I understand. Your Honor, this is one of the acts that's listed as an overt act in this indictment. As I'm reading it, page 66, line 12 starts out talking about the gun that Mr. Zachary got caught with on May the 7th, and then Investigator Dennis goes on to say the assault rifle you're in the video with, and he's saying what it came back to. And then you have Mr. Zachary saying that's Moon's gun. But he is acknowledging that he and Mr. Sledge, who the state alleges, Mr. Sledge already pled, but Mr. Zachary is indeed YSL. So they're swapping guns. We would just argue that this is evidence of count one and the gang count in this case.
That's not my issue.
Count one.
Okay, so do you have an issue with lines 8, lines, where is it? 12 through 18?
I do have an issue with 12 to 18. I don't have an issue with him saying that he gave the gun to Moontook or that's Moontook's gun. That's fine. What I have an issue with is saying with Investigator Dennis, saying that the ballistics from that gun matched the May 7th shooting of Lucci's Bennett's
Okay.
mom's house. And there's a couple reasons. It's not Bennett putting that.
Okay, well, hang on. Maybe we can address your objection and still have in the portion that Ms. Love wants it for
So it's
by
really 16.
redacting a smaller part of it.
I should have said 16 to 17 if I was
Okay.
to be more precise.
Okay, so any issue with just with redacting out 16 and 17, Investigator Dennis's statement about it having come back to that?
Not for the purposes of Quindarius Act. No objection at all.
Okay. So. So that's 66, 17 through 18. Out by agreement. Okay, and next we move to 68, 24, and 25.
It's,
I was.
Yeah.
Was the court asking?
I don't, Mr. Sharp, did that have some issue?
right, 60, they're going back to Lucci mom's house, and then they're saying the gun you got caught with has something on it until you didn't know until you went to court.
I'm going to let that keep playing just a little bit, but I just wanted to comment on this comment. I'm convinced that Woody will come back and plead the fifth and stay in jail until the end of this trial. Without Woody's testimony, there's no case. What was interesting is Woody was just there for how long, and what was he asking? He was saying, how long will I have to stay in jail until the end of just this trial? I mean, for somebody who's gone to jail as many times as he says he has, how much is there a fear of being in jail? Could be, could not be. But I think it's interesting that when, according to the judge, what was told to him was factually incorrect. So when they actually tell him the facts of how long he actually has to stay in jail, what his kind of options are, is he going to choose to testify or is he not? Which again is important because to the second part of this comment, a lot of the state's case is built upon the police interviews that Woody gave. There's obviously other testimony and other witnesses. They're talking about the witness after Woody, which would be Quindarius Zachary, who again gave some police interviews. So some of the state's case is built on that. But if you remove Woody's testimony, what are you left with as far as like what other, does that affect the other witnesses that you're going to call? Because do you need his testimony for the foundation of whatever story you're going to tell? You need that first testimony, and then you build on that. You have witnesses come in and testify about stuff. But if you don't have him to tie it all together, what does that do to the state's case? And I think that's going to be really important.
In this particular case, when Dennis says what he says, Mr. Zachary doesn't say, what? Oh my gosh, no. Instead, he says, it has shootings on it. Yeah, it has some shootings on it.
He says that because they told him in court the day before. He didn't know.
But Judge, Mr. Sharp can't be the witness in this particular instance.
I'm going by what the transcript says.
I'm saying though that he can't speak to why Mr. Zachary said, yeah, it has some shootings on it.
I'm gonna exclude that. I mean, honestly, it looks to me like he's saying, yeah, I mean, now that I know, I'm not surprised, but I mean, if that's what you wanted in for, make that argument, but I didn't hear that argument, so that would be lines. So you're saying, hang on, Mr. Sharp, on 68, where are you proposing that redaction start?
19 to 24.
19 to 24, okay. I am gonna exclude that.
I'm not sure I'm reading this correctly. So Mel, when they call the witnesses back, will they be I'm assuming you maybe mean jurors. When they call the jurors back, will they be focused on the items or topics that they decided to strike here? Right now they're talking about Quindarius Zachary, but for Woody's testimony, everything after the 12th will be excluded. And so there's two parts here, right? They're calling Woody back to come on the stand to determine if he's going to testify at all. And so if he doesn't, the whole thing would theoretically be stricken. But if he does testify, everything after the 12th would be allowed in. And so she would just instruct the judge on that. I mean, the jurors on that. I don't know if I'm answering your question. I don't know if I explained that properly. If I answered it.
Gave you the gun, and they don't have an issue with, we'd like to know who gave you the gun, just we found out later this came back to the shooting.
That's fine.
Okay, so that is 2 through 6, starting on January 26th, are out by agreement. Okay. And then 17 we already did, so the next one is actually 18, page 69, line 25 through 7213. And
Okay, so
This is a part of why they are saying it needs to be a mistrial, because I think somebody else said it. How do you unring a bell? How do you tell them, hey, forget this, but don't forget this, right? Like how do you tell the jurors that? And that's a part of the motion for a mistrial. How do you do this? Legally, right? There is case law that would indicate instruct the jurors. And as long as you give a jury instruction, you've covered your bases, you've done what you're supposed to. But realistically, I think is the problem. How do you do that?
and if he doesn't, if he testifies inconsistently, it should be able to come in. I'm not looking at his reason for asking it.
She has not ruled on the mistrial. She just gave another extension to the state, told them that they needed to have a response to Max Shart's supplemental that he filed for the motion for mistrial, and then Doug Weinstein's motion for a mistrial. She gave them until Friday because they never responded to those, and I was waiting. And so she gave them till Friday to actually file a response. So there has been no decision on the mistrial yet. And low key, with every every new piece of evidence, it seems like she's entertaining the idea more and more, in my opinion. I was heavily leaning like she's not going to grant it, but I think there's a real possibility that either these prosecutors are disqualified or there is a mistrial. That's just my opinion, but y'all know I'm not a lawyer.
There's just so much rumor and back and forth in this case. And I think that the investigators, I'm not trying to criticize them, but they're just trying to like gather information, not in preparation of trying the case, but just trying to get like some broad generalized what the word on the street is.
So, Your Honor, as with any, evidence or testimony that we elicit or tender, we have to establish a foundation before it's admitted. So
I hope y'all don't mind that I keep doing this. I'm kind of muting and unmuting, but it's just because she's just talking about the Quindarius Zachary's testimony, police interview. So I hope y'all don't mind. But do you think they will have to go through their notes and redact what was written? What they would probably do, we'll see. But the court would take their notes. They could literally take the notes from his testimony. Like if it came down, they could take them. So yeah.
What about Thug's stepdad's house? He actually says, I don't know for sure who did that one. So, I mean, he's clearly, if he doesn't know, he's like, beats me on that one.
Well, I think, I don't speak for Mr. Zachary, but I could see a world where he's a layman. And so he's saying, well, I haven't heard, I don't know for sure means I haven't heard anyone, no one's told me about that. And I just think, I don't think the co-conspirator, and I'm not saying that Your Honor said this, but I don't believe that the co-conspirator exception is satisfied by just saying, oh, well, it was a bunch of co-conspirators talking. I think that they need to establish who said what to whom and where in the circumstances of that statement, so we can see if it falls under 801 D2E. And
Well.
so that's, I'm in the blind right now as far as how the state plans to get into that. But what I don't want to happen is the state, when Mr. Zachary's on the stand, to try to bring up, well, who do you know who shot?
Two things. Number one, this is one of the major bases for Bruce Harvey's motion for mistrial, which she denied, but it was that you don't have enough context. You haven't been here. So when I ask you to rule on something, when I ask you file a motion for something, you haven't been here to even understand the history of what I'm asking for, right? If I ask you to strike, Woody's testimony, you weren't here to witness the chaos, right? Or you weren't here to understand Tick's testimony or DK's testimony or D'Angelo White's testimony. Like you weren't here to understand when I'm asking this, there's a history of something, there's a pattern that has existed. And so you're ruling on this in isolation instead of the full context. And that is the basis for Bruce Harvey's motion, which was denied. But I think it is a good point. The other thing I will say quickly is that because, of course, Woody's testimony was comical in many ways. And a lot of people were saying, like, how do you forget that? But also it was forgettable because he didn't say much. And one of the things we were talking about in my Patreon yesterday is that when you think about going to a comedy show, right? When you think about going to a concert, you remember the good people. You remember the best singers. You remember the funniest comedians. You remember the people that really put on a show. And so, do you remember all of the detectives that have testified? No. But you probably, if you've been watching, you probably remember Detective Gaither. You remember the encounter between Max Sharp and Gaither when he kept saying, "Where are your reports?" So, yes, it's been a lot of people. Yes, you may think it's easy to forget, but I would argue that the funniest people and the best singers are the people you remember. So if Woody is the one who stands out, you remember him, and you remember, this is the other part, he didn't just testify. They also played some of his actual police interviews. They actually played some of that already. And so if you've been paying attention and you've been waiting for the moment to understand, how does Lil Wayne actually fit into this? How does Birdman actually fit into this? When they played those interviews, he puts a story together for them. So if you are paying attention, you may not remember everything, but you may start to remember the story that was put together through the police interviews of Woody. And that is what I'm saying is problematic. How do you forget that? You remember D'Angelo White. You remember him saying, take me back to only corrections I do is Department of Correct. Like, you remember all of that. You remember the incident I will never forget is the car going airborne and landing into a laundromat. Like, in my mind, like, what were y'all doing? But you remember the context of that. You remember. And so all of that, you remember Tick's testimony. The one thing about Tick is that at one point he was, being kind of elusive, but eventually one day he came to court. He had a haircut. He had a button-up tie on, a button-up shirt on. And what did he start doing? She asked him questions, and all of a sudden she said, who was in YSL? And he was like, him. So up until that point, he was elusive. But I remember the moment that turned, and all of a sudden, oh, looks like they're going to lunch. All of a sudden, he started naming people. And so again, when you are there, some of it is funny and but certain things I would argue, and I'm not a lawyer, but I would argue certain things start to stick out. And that becomes the danger. And when you're thinking about Glanville, who was ruling over this case, Glanville, who was presiding over this case, and did he, rule correctly in allowing so much hearsay in, right? Like, those are the things that start to, in my opinion, really start to be an error in this trial and make me start to question, how do you have a fair trial? How do you continue on from here? But I'm not a lawyer, so y'all know how it goes. They went to lunch. I'm not going to go back because all they were doing was still going over Quindarius Zachary's testimony. So I'm not going to replay it. Let me see if there's anything else I'm missing. I remember Grown. You remember when he pled the fifth. You remember Grown, and the context of that is he pled the fifth. So yeah. Listen, YSL jurors are welcome to hear. If you're a juror and want to tap in, you're not a lawyer, but you want to tap in on the conversation, everyone's welcome. Anyway. Let's see, I'm missing anything. I appreciate, though, this judge is trying to be thorough. So whatever she does decide would have had some due diligence behind it. I agree. I mean, even the fact that she's doing what she's doing now, going through line by line. Again, I think I said this in Patreon, but the difference is the state was arguing, hey, prior inconsistent statement. And so he would be like, yep, let the whole thing in. Or statements by a co-conspirator. Yep, let the whole thing in. And Judge Whitaker is like, you don't just get to let the whole thing in because you're saying prior inconsistent statement, or you're saying statement by a co-conspirator. That's not how that works. Show me the precise statement by a co-conspirator. Show me the precise inconsistent statement. It's not the whole thing. So I agree. She is like taking her time and actually going through it, which is a major difference between her and Glanville. He did not do that. So a lot of stuff was allowed in through hearsay. And that's not how that works. Exactly. I don't feel like they are innocent in this. I just feel like they haven't been afforded a fair trial. I also think they went about it all wrong with the RICO. I agree. Listen, I won't make an opinion. The reality is everyone is entitled to a fair trial, and what has been happening hasn't felt fair. That is the only I'm not saying that all of these men, all of these defendants are innocent. There are obviously victims, people who have died, and I do believe people deserve justice. So be clear on that. But I also believe everyone is entitled to a fair trial. You don't get to cheat. And in addition to that, naturally, the state typically has the upper hand in a case. So you don't get to have the upper hand and still cheat. Bruh, that's unfair. There are some updates on Karen. I have to Karen Reed, if you are unfamiliar. So listen, matter of fact, we're on lunch. I'm about to take my camera off because I got to finish the recap for yesterday. People are asking, where's the recap from yesterday? So I have to look, here's a comment right here. I was hoping for a recap all of yesterday. These other places don't do them right. I'm about to post the part 1 recap of yesterday. I have to do what happened after lunch, but I've been live, so it's been affecting my ability to get it all out. And I need to do the fact that Woody is going to be coming back. So I'm about to get off here, turn my camera off while we probably take an hour for lunch, but it's coming, I promise. And I appreciate y'all watching and harassing me about it. I like that y'all watch it. Thank you. Let's keep going. They usually have an hour, but I probably should rewind to see what time they're going to come back. Are they all in trial together because it's a RICO case? Yes, you can have cases where people are like co-defendants and it's not a RICO, but in this situation, they are together because it's a RICO. But like if you are familiar at all with like Y&W Melly's case, right? Like it's him and Bortland, they are considered co-defendants in that case because they are both charged with the crime of killing those 2 men. So they are co-defendants. They opted in that case to try them separately. But they are co-defendants. So that's the situation here. And so people in this case have been severed. So people are going to have court separately, but they are together. And the basis of that is the RICO. I hope that answers that question and it's not more confusing. Yeah, I see him saying co-defendants. Can you replay when Woody came in? I can go back. Yeah. No complaints. You were just missed. Thank you. I promised I have part 1 ready. Right. I posted it on TikTok. I just haven't posted on YouTube because I was live, but I'm gonna post it. Let me. Oh, 115. Okay, so we got a little bit of time. 1:30. Oh, 1:30. 1:30 they return for lunch? Okay, so about an hour. That's gonna give me enough time to post this, and I might be able to. I got to figure out if I'm going to try to do the recap for the second half of yesterday or try to hurry up and get out Woody from this morning. I need to put that out because, of course, people are saying, "Is Woody coming?" And I need to post because it's happening. 12:30. Okay, definitely 1:30. Okay. But let me post. Somebody asked for when he came in, so let me just play it really quick. There he is. Hold on. If you want to watch it, I'm just going to post it and then we can.
I'm Judge Whitaker. I think you've been before me before. Hi, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters.
Huh?
I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know one to testify.
Okay, the first, well, right, want to is maybe the wrong term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know whether.
I was talking to Melanie, but
Melnick?
Yes.
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay, does anybody know whether that actually occurred?
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was standing and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was,
there was
but,
nothing about Mr. Melnick to my knowledge.
okay, maybe
There was, Miss Bumpus actually said, yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his, he
well,
could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right.
I
Well, then
guess.
that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity, understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify, so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial. But I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
here? To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you.
Indication of what his source of knowledge is. I think he's
Yeah, right. I mean, obviously, if he gets up and you ask him about it and he tells.
and then they say, well, didn't you tell the investigators that Woody and Shannon and Pokey did it? And it's like, it was just based on nothing, but it's already out there now.
And Judge, that would be a leap. That would be to say who did it and then didn't tell him. I would at the very least establish a basis for his knowledge, either from things that he has said previously or from things that he says on the stand. So it wouldn't be as if it would be some kind of backdoor way to get in somebody's name. That.
I have to fast forward. I'm just trying to get to her talking about Melnick.
Pulling out evidence of a witness on the stand. It would be establishing a foundation for knowledge.
Okay, but we're assuming if this comes in, that it's coming in because it's coming in as an inconsistent statement, you're impeaching him, right? I mean, obviously, if he gets up and you ask him about it and he testifies to all of it on the stand, then there still might be a foundational objection, but then we deal with that then. But if you're getting it in because you're having to impeach him, that's what we're trying to decide now. And so I don't want to wait and have the jury there and make the jury go away while we figure out the basis of his knowledge, you know?
Yes.
So I don't know if we'll swing back around to that one. Okay. Let's see.
Just trying to get her to talk about Melnick. That's all.
I mean, and frankly, it's probably going to be the same. You're going to need the same information for a foundation, regardless of its as to his testimony on the stand or as to this, you know. But yeah, you kind of let us know what that's going to be, so that I can make a determination of whether it comes in, you know, potentially. Well, that was 18. You agree about 19, so we're moving to 20. And y'all just let me know when lunch gets here and we'll break. Oh, it is here? Okay, we're gonna break then.
Am I missing her say it?
All right. Great. So it's 12:15 right now. So far, Ms. Rosser has not been able to reach Mr. Melnick. So, you know, it's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break until 1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30.
Okay, so there it is. She has not been able to get in contact with Melnick. We'll see if he shows up. I see this question. What would happen if Attorney Melnick withdrew? If he withdrew prior to this, then they would have another question. The judge was talking about potentially like reaching out to someone because she doesn't think he would be able to get a public defender, but she seems like she really wants him to have representation. But if he did not withdraw prior to this, I don't know that he would be able to. Copeland would have to agree to that. The same kind of thing that was going on, not to that extreme, because Glanville was being a little crazy, but he would have to agree to release him. But he couldn't just be like, yo, I'm tired of this. Y'all get on my nerves. I'm done in the middle of this. So we'll see. We'll see if that is the case. Also, it's maybe he's in court. We'll see. I saw somebody said, here it is. Melnick has tossed his phone in the river. He is watching on YouTube live right now. Like, no, his wife probably is. I don't know if he's married. I was going to say his wife probably got rid of his phone, but we'll see. We will see. Where is Melnick? We will see if he gets back to the court or if it's going to happen tomorrow. And again, the thing that is going to happen is we have to dig, not we, I'm not a lawyer, but they are going to dig into if he felt coerced in that meeting. That's what the point is in that meeting, especially considering that based on what the judge has said, he was given incorrect information, which again, that's the first time she's acknowledged that what y'all told him was wrong. And she pointed out at least 3 examples of things that were wrong, factually incorrect. That's interesting. That's interesting. She has not ruled on the mistrial yet. She has not made a decision. She has not. She keep pushing it out, even though we keep trying to ask her what's going on, but she keeps pushing. So we'll see. I'm going to work on uploading the first part of my recap from yesterday, work on recapping when I can, the second part, and then I need to post this morning. But now that he may not testify, I don't know if it's as pertinent or like as much of an emergency, but we'll see. What the defense is asking is that if he was found to be coerced, he doesn't have to testify at all. Like the whole testimony is stricken and he is not able to be called back to the witness stand. Yeah. So if he was found to be coerced, that is what they are asking for the remedy, for the relief to be. And that's what she has to decide on. So less about the immunity, I guess, is what I'm saying, if that answers your question. We were not back. I just did some rewinding because somebody had asked to see Woody. So I just rewound it. Oh, and yes, Hilton, I saw somebody ask that. Hilton is on vacation. She said that she had previously scheduled, amen, these lawyers got vacations. She had vacation scheduled. That's why she's not there. Based off of what the defense is requesting, because of what they are saying was coercion, it's depending on what the judge is going to rule, but it could be very impactful is the word that I would use. If he is found to have been coerced, that could be impactful to their case in a couple different ways. It's going to depend on what the judge rules. She has options, obviously, but it could matter for them. You know what? I should probably have an actual lawyer, because I'm not one, come on the podcast to talk about this, because I saw a couple takes about Brady not being Brady because you have it now. So really like the transcript of the ex parte. Okay, it's not a big deal because now you have the transcript, when the reality is what they had to do to get it, and if it was intentionally hidden, right? And so I'll do a very quick explanation of Brady. If you watch the podcast, you heard me kind of, and I think and an actual attorney kind of walk through this. Brady is material that is exculpatory to the defense. It is information, evidence that that could show that the defense did not do a crime, right? If I accuse you of murder and I have evidence that someone else did that murder, I, as the defendant, am entitled to that information. You don't get to just hold that away from me. And so Brady is just like, I'm entitled to it regardless. And so I am not a lawyer, so I won't specifically say. I think it was an interesting take for the judge to say that about the transcripts, based on what they had to do to get it. But again, I think that again has to do with her like lack of context. And I think yesterday, what happened through Caleb Bumpus's testimony, and then Detective Long or Investigator Long, who came up afterward, I think she got to see very clearly that there was more information. There were things that happened in that ex parte that, even with the transcript, was not known to the defense. So we'll see. I don't know. That was probably a non-answer, but oops, sorry. Oh, I see somebody. You're saying, can I explain Brady? I can do a better job of it. I can do a better job of it. I was trying to not take a long time so that you guys are not bored with me. But basically, I'll tell the story. There's a man named John Brady, okay, in 1963, I think, in Maryland. John Brady and another guy, I forgot that guy's name, but it was John Brady and another guy are accused of murder, okay, of murdering another man. The other man, that's not John Brady, tells the state, the prosecutors in that situation, that he killed that man. The prosecutor, so they find out that this other guy has said it. The prosecutors never tell John Brady that, hey, this co-defendant admitted to killing the man. They never tell him, and they still prosecute John Brady for the murder. They prosecute both of them. Both are found guilty. Afterward, John Brady learns that, hey, prosecutors, this guy told y'all he did it and y'all didn't tell me. So that is and the Supreme Court agreed. They have a right. John Brady had a right to know that. So that is the basis of Brady. That's where it comes from, the man named John Brady. And so anyway, they ended up sending it back, and he didn't completely get off. John Brady didn't completely get off. But that is the basis for Brady. So it is very similar into what was being claimed in this YSL case, because remember, Brian Steele said in this ex parte meeting, what he was alleging, which doesn't seem to be the actual case, but what he was alleging was that in this meeting, Kenneth Copeland admitted to killing Donovan Thomas. That's what he's alleging, which is very similar to what happened in the John Brady case. This other man admitted to a murder. And that's why, if you were watching, Brian Steele said, this is the greatest Brady. That's why, because it's very similar. Obviously, through what happened yesterday, we learned that he didn't just outright, Kenneth Copeland didn't just outright say, I'm the one who killed him, but he just alluded to some other things. And so they're still saying there's still some Brady here. He's still talking about this infinity, which again could be exculpatory to the defendants. What about this infinity? What do you know about it? And there's somebody that's not even involved in this that has something to do with it. Like, what is this? So that's essentially what the defense is trying to argue, that there was some Brady that happened. Hopefully that makes sense and answered your question. Hopefully. I'm going to update Karen Reed. I have to like read the documents. I just haven't because I've been swamped with YSL. But yes, I'm going to do it. Okay. I was like, it is. I thought it was Maryland. I know it's 1963. I thought it was Maryland. Yes. And this is why, this is my mother. But yes, if you think about Alec Baldwin, it was Brady. The whole problem was the state became aware of some evidence that could exonerate, right? That paints a different story than the story that they were putting across, and they never told the defense. That's why that case was dismissed with prejudice, because it was like this is a big deal. Brady evidence is a big deal. It can be. You have to prove it, and it can be difficult to prove, but it is a big deal if it is violated, if the state does not turn over what they are required to turn over. Yes, I plan on following Sarah Boone. That's the one who's had a lot of attorneys, right? I plan on following that one. I got to catch up. She did say this. And this is the other thing that was yesterday, I think. Whitaker said she takes it very seriously, which was encouraging because I'd argue Glanville didn't. But she did say that. And that was there's been a couple things Whitaker has said in the last 24 hours that have made me wonder, oh, okay, she may actually do something about this. She may actually, I have been feeling like she was not going to grant this mistrial and she was just going to press forward. But in the last 24 hours, I've been feeling like, oh, so she is paying attention. There is some stuff that she has problems with. So it's becoming more interesting. But yes, you're right. She did say that yesterday. You know what? And this is why I need to do the second part of my recap, because in listening live to Caleb Bumpus' testimony, it felt live for me. This is just for me. I felt a little like, confused, like, oh, what is she saying and when? But this is why I do recaps. When I was able to go through it, when I was able to go back through it and edit it together, the story made much more sense that she was painting. And then, of course, when Investigator Long got up there, he basically said the same thing she said. And so I think that she did, it felt confusing in the moment, but if you haven't watched my recap, I got to post it so you can watch it. And I think you'll be able to it'll make more sense, versus how it did live, at least for me. All right, y'all. I gotta, you said it's very confusing. Can't we watch the recap now while we wait? I need to, okay, I'm about to get off here so I can post it. And then I need to still do Detective Long I keep calling him Detective. I need to do Investigator Long's because I should have put them all together. But once you see Kayla and then you see his, I think you'll be able to see very clearly, oh, these stories do match. In isolation and like with all the extra, sometimes it kind of takes away from the meat of what somebody is saying. So anyway, that is my point with the recaps, is that hopefully it takes away all that other stuff and you're able to see like, oh, okay, we see how this works. Um, Okay, so I'm gonna go do that. I'm gonna get off of here and go edit so that you guys can see what I'm talking about, and hopefully it'll help. So 1:30, so we got like 45 minutes. I'm gonna leave this link live. It'll just be muted. And so we'll be back in about 45. Go have a snack or something.
don't have.
Oh, perfect. Yeah, that's probably more pressing. So, okay. What do you know on those?
So. I'll start out with just the fact that the language of the statute itself, is part of the basis, well, actually was the basis for the interpretation that we had regarding.
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me.
I don't have a copy.
That's fine. It'll just take me a second to get it pulled up. So you're talking about 24.5.507?
Yes, Your Honor.
Okay. All right.
So, just the plain language of the statute, so, just the plain language of the statute, Your Honor, which is essentially a statute, not saying that, the court can grant immunity, but that the state can grant it and we have to move the court. It lays out very specific steps that we have to take. And in.
Hang on a second. Can you not hear her? All right. Can you, I don't know, do those mics move?
It wasn't on.
Okay.
It wasn't on.
There we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in section A refers to both. And it talks about the fact that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury and don't reference the trial jury. But given the fact that the statute itself refers to them almost interchangeably in section A, when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert a Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I
okay.
haven't fully got it. It's in Long, 276 Georgia App 306. I'm reading it.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. You know, that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but
And in reading, and it's a 2005 case there, so I haven't looked carefully at it, so I don't know if it's cited in the annotations.
it is for a different proposition. I haven't read it myself either, but
So the judge's statement was that you guys
I
gave,
don't know that this case really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is I sort of feel like it couldn't go past the end of the trial.
Mhm.
But it doesn't say.
But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, I don't have a case on point, however, it would make logical sense that it couldn't go past the end of the trial, however Mr. Copeland purged himself of contempt.
Where's one thing?
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But, you know.
And arguably, the testimony would be under oath and available. I'm
It was not going to be available at, I mean,
not at that trial.
Right.
Yeah.
so I'm sort of going with through the end of this trial unless somebody tells me differently. All right, has anybody come up with anything else that he ought to be advised about?
I know that the court did advise him that. Westmoreland, can you hear me? I know that the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of lays it out. And I know that before he testified, the last time Judge Glanville, I think, gave him a copy of it.
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think.
Oh, in court.
Yes,
Okay.
he gave to Mr. Copeland, read to him or gave it to him a copy of the statute and apprised him.
Remember
I think he made.
Okay, right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up. But I went up a whole degree, so I'm seeing if a half degree will make a difference.
I will survive. So
What were we saying? Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page, at 10:03, and it goes until 11:30. And I mean, there may have been a break or two in there, but so I realized that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example, if I can find it. Okay, so on page 51, the example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but I mean, there'd have to be some, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the stand, when he was trying to speak with Ms. Hilton out there in the foyer area.
Yeah, and then, we also discussed the immunity versus statute of limitations. And yes, the immunity, because he has been given immunity, protects him from being prosecuted based on anything he says, if he says anything. And that is true. But he was also sort of told, you don't have any statute of limitation worries either. And that's not necessarily true. And it may have no practical
That's what I was
effect
about to say.
because if he can't be prosecuted, he can't be prosecuted, even if it's for something within the statute. But it was technically not necessarily 100% accurate information. Whether he in any way relied on that, I'm not saying that at all. But I just want to make sure we do it entirely to the extent we can correctly and accurately.
So would the court be inclined to read him the statute and then respond? I don't know. I'm asking. Respond to questions because, for
Sure.
instance, I even heard, it may have just been a misstatement. Obviously, and people communicate differently, but when Mr. Melnick was saying regarding how his testimony couldn't be used, but we could use the testimony we can't.
So I don't know. Some people keep saying he's got use, and then some people are saying he's got use and derivative use. So I probably need to look at the order.
I wrote the order and I literally modeled it after the exact words in the statute. Like I took the statute and put it in the order for the most part. And so the part of the statute that says that no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning.
That sounds like derivative use to me.
And so that, that was in there from the start. And
All right. And yeah, do you want to, I can, what's the perjury statute?
She should read it herself. Not plagiarism.
I will look it up.
And frankly, I'm not sure that either giving him or reading him any of these statutes is going to be particularly helpful, but that's why I would like for him to have counsel so counsel can explain to him, here's what the perjury statute means. Here's what your immunity order means. Here's what a prior inconsistent statement is. Here is what you face if you decide not to testify regardless of your immunity. And then, sure, if he has any questions of the court, still we can entertain those. But
And I don't know how wise it would be to even make the request that if his counsel seeks to understand the extent to which the immunity exists, like if he would speak to us, but
well, maybe we can
you-
dial down from all of that too. That's been several weeks since y'all all made, assertions about whether or not who knew what when and who was professional and who wasn't. And maybe I'm going to ask Mr. Melnick and you to move past that. And
I'm beyond it. I would.
you're beyond it. Great.
my
We'll
husband.
see if he is.
And I would love to be able to fully explain, to allay any fears that he has or concerns about his
Sure.
client's criminal exposure, but 161070 is the perjury.
Okay. And then I ought to know prior inconsistent statements by heart, but which one is that? 24 something? I don't know. I'm sure I have it in front of me somewhere, but I think those would be the four relevant things: the order 507, perjury statute, and prior inconsistent statements. Whatever, I'll figure it out later. I can find prior inconsistent statements.
246630. Wait. Twenty-four six six 13. Witnesses prior statement. 246613B.
So Ms. Pressfield's been doing some research, and at least the federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but
Is court proceeding the indictment, or is it the trial of a severed, because if
I-
people are severed? Like,
I don't know the answer to that.
Yeah.
Yes. Yes, I don't, who said that? You did what? Say that again.
Email.
Ah, okay, to Ms. Firstfield, okay. And do you have a short answer for me?
Yeah, we don't just hold people in custody. The U.S. Supreme Court cited in footnote 1 from the Middle District of Tennessee, our issue is deposition, person refused to testify, no trials coming up, they were not set yet. The government's position is like the state of Georgia. Government's position is like the state of Georgia here, just hold the person.
Thank
because
you.
The case is not resolved. And the Middle District, the district court judge gave reasons. And then the footnote they gave the U.S. Supreme Court that the contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue the same contempt over and over again. They can bring an obstruction of justice indictment against the person or a contempt criminal charge against the person. But we don't just hold people because it becomes, and there's other cases I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right,
And at some point they're not doing the act.
yeah.
Otherwise, according to Ms. Love, I mean, really, according to Ms. Love's reading, we could just hold them until it's 50 years
die.
later. Yeah.
Yeah,
I mean, at
which
some
can't
point,
be the law.
And Judge,
And I know you're not arguing that,
Could
but
the court permit me a moment to just review the case that Mr. Steele just sent?
sure,
over?
did you
I
send
got
it to
time.
everybody?
He did. I got
Okay,
time.
yeah.
I just want to read it.
and Judge,
Mr. Matthews.
Similarly, is civil contempt, and I'm looking at In Re Estate of Banks. In Re Estate of Banks is going to be 339 Georgia App 144. It says under Georgia law, when the trial court orders incarceration for an indefinite period until the performance of a specified act, the contempt is civil. A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to comply. The moment it appears that there is inability, it would clearly be the duty of the judge to discharge the party, because the purpose of civil contempt is to provide a remedy and to obtain compliance with the trial court's orders. The justification for imprisonment is lost when the compliance is impossible.
Thank
That was
you.
good.
I think you have hit
I
on
think
the
so too.
exact case we needed.
Yep.
So that answers the question for me.
Yep.
You can look all you want, Miss Love,
End
but
of
I
this
think that
trial.
pretty clearly answers the question. Logically speaking, that was kind of what I was feeling anyway, but now we got case law to back it up. Good deal. All right, so
Who was that did it? Good job.
I am proposing that if Mr. Melnick is in fact representing Mr. Copeland, I ask Mr. Melnick to please make sure he understands the order, the scope of his immunity, which I read to be derivative use as well, and what perjury means, what false statements mean, what could get him either of those charges, legally speaking. And I know Miss Love, you and Miss Hilton had said there are certain things that even. Okay, well, in your discussions conceptually with Miss Bumpus, but I'll leave it with Miss Hilton, had said, I am not intending to charge you with perjury if you do X, Y, or Z. I am intending to charge you with perjury if you do A, B, or C. And Miss Hilton's not here, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know. If you get up and say something that's not material, like, you know, oh, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant. Then I'm not going to charge you with perjury for that.
And I think that that was along the lines of what the intent was, but the intent isn't really an issue. It's the reading it. I'll just say I agree with what the court is saying about that.
And, you know, if you then say, I don't know, I don't remember, blah, 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 to whatever, every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr. Melnick can explain all of that. But I would just propose to make sure that I ask Mr. Melnick to explain all of that. Then he can confirm, yep, we've done that. And then if he has any questions, we'll take questions. And I'm even happy to say, you know, sorry, when you get a jury question, we can huddle and go, I'm planning to say this. What do y'all think? If y'all want me to do that, or I'll just wing it either way. If y'all are fine with me winging it, I'll wing it, but don't wing it. Okay. All right. So that's kind of what I'm thinking we do at 3 or 3-ish or whenever we have Mr. Melnick available. And then maybe give him, assuming he is the attorney,
An hour?
overnight to fully advise him of everything. And then we'll have him in maybe first thing and find out what he's intending at this point.
John, I inquired the court regarding the court's earlier statements about the case that Mr. Matthew cited. When it talks about an impossibility, is the court's understanding of that after the trial is over, after this particular portion of this indictment is over, it's no longer possible to purge oneself?
It would no longer be you've said I'd have to have your motion in order in front of you, but as I understand the motion in order at this point, we need his testimony for this trial. Now, you may also need his testimony for some other future trial of some indictee in this indictment. I would think you would need to seek and secure another order. I don't have it in front of me. I can look again, but that is my read on this. I mean, you may never try another person. We don't know that. So how can it not be that, as far as we know, he's no longer able to purge once this trial is over?
Theoretically, given Part B of that statute, would he not?
I've made my decision and I get it, but I don't think that, I just don't think that supports your argument. So I think unless and until you can bring me more law, I'm done with it might mean to this part of it. Okay.
That's Glanville would never.
All right, so
He would keep going back and forth until he changed his ruling.
let's go back to our
And yeah, she eating something.
narrowing down, figuring out what needs to be redacted out from these statements of Mr. Zachary.
John, may I inquire one more thing? If Mr. Melnick intends to not represent Mr. Copeland, what is our position at that point?
I guess we can ask him, does he want an attorney? And I have inquired, because I don't know the answer, of the public defender's office, whether in a kind of situation like this, where you have somebody who could have been indicted, who's not currently indicted, who's been given immunity, assuming he would qualify for their services, could they or some conflict attorney provide representation?
Judge, I would tend to agree that seems to be the most sensible thing to do. I mean, at any point where someone's liberty is at issue, the court should at the very least inquire as to whether or not there's representation that can help a lay person, Mr. Woody is, navigate his way through these things. So I would agree with the court's inclination.
Okay. And if for whatever reason, a public defender or conflict defender cannot represent a witness, Although I would think they could because of what you said, as long as they qualify, his liberty is potentially at stake, then, but if they can't for whatever reason, then I don't know, we just have to.
Then I
either-
would suggest that the court take it upon itself to do the best the court can to advise the witness appropriately without any input necessarily from either party. The court is less vested in Mr. Copeland's testimony than either side, and so I think it would be the court's responsibility at that time.
What's certainly ultimately my responsibility, but I am soliciting from both sides whatever they think would be appropriate to advise him about. And I can then take it all and look at it and
Sure.
put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given issues that have been complained about his prior advisement. So,
Good.
all right. Okay, so let's turn to, somebody needs a bathroom break. So I know we just got back here 30 minutes ago. Y'all should have gone to the bathroom before then, but we'll take a bathroom break quickly. I'm just going to stay here.
One of the things that she just raised, I don't know if you guys caught what she said when she said previous advisement. What she is getting at is and one of the things, I'm not saying it's valid or not, I just am explaining. One of the things that Love raised and that the judge it seemed like that she was just alluding to was that Kenneth Copeland, when he was first advised in that ex parte, had representation. And so what she was saying is, the complaint about the advisement that he previously gotten is that, and what I think Attorney Love was trying to get out from maybe Kayla Bumpus when she was on the stand, is that he had representation in that meeting and in front of the judge. That's the other thing. All of this happens in front of the judge as well. There is incorrect information being given to him, and neither his representation or the judge corrected it, right? Like, this information is being given from the state and no one in the room corrects it. So that, I think, is what she's getting at, is like, obviously he doesn't know. And he, at this point, needs to have somebody who represents him, who is able to inform him of what exactly he's being presented with. That's what it seemed like they were getting at. The other thing is, again, from what I'm taking from it, she's all about like moving forward, which I see. The problem is what I just said. That information was given in front of the judge, right? He was given incorrect information. He is given immunity. And so on one hand, is he saying, okay, if I have immunity and you can't prosecute me, then I can go up there and claim everything? Or is he also saying, or on the other hand, is he saying, y'all don't know what they're going to ask me. You don't know what I've done. I could go up there and claim. Like, there was so many parts to this, and it doesn't seem like the judge is focused on how improper and ridiculous that ex parte meeting was and the information that Kenneth Copeland was given, which then impacted, according to the defense, his decision to testify. It seems like she's less worried about that and more worried about, okay, we're starting fresh. What do we say to him now concerning the testimony he may or may not give for next week? So it's less about like, this happened, this matters, this is a problem, this should be a mistrial, and more about how do we fix it? Which again is why I keep going back and forth on, is she really weighing what happened, and is it amounting to a mistrial in her mind? Because sometimes it gives that it doesn't amount to a mistrial, just amounts to, we can fix it. But yeah, I think Matt Ricks just said coercion. When it comes down to it, and this again, why it's so surprising, when it comes down to it, if Kenneth Copeland walks into that meeting saying, I'm not going to testify, and then is given, according to her, at least 3 points of misinformation, 3 factually incorrect information. She said, I don't know if he really cared about it, but she doesn't know, right? So if he is given this information, all of this is weighing in his head, and that is what prompts him to then testify. And it was incorrect info. You gave me wrong that's bait and switch. You gave me wrong information to get me to do what you wanted me to do. I don't see how that's not coercion. I don't see how. I mean, even if it was like, the whole point is they were all a part of trying to coerce him into doing what they wanted, and then gave him wrong information. That's why it's wild to me. That's what I'm like, girl, how do you fix that? How do you, it's his testimony has to be undone. It's so surprising to me. It feels like she's less, I agree, Trishelle, she's less focused on the actual violations, on what happened, and more about how can I fix it going forward. But, yeah. And I mean, so the immunity part, the derivative immunity, which it sounds like maybe she did give him derivative immunity, but regardless, he was not given absolute immunity. And then regarding this, like, statute of limitations, which is incorrect information, like, they were giving him information that just was not factual in order to convince him, is how it appears. I don't get it. I don't get it. But it comes down, and this is why it could suck. I'm not saying this is accurate, but if he's given incorrect info, I don't know how you fix the judge. I was going to say, if he's given incorrect information, but has an attorney, then he was advised, like, he had the representation. I don't know how you fix the judge, though. If the judge is in there and heard any part of it, which in the transcript, he was there for some of that. I don't know how that's not problematic. Recused or not, I don't know how that is not problematic. This is funny. Did use a case from 1978, and Judge Whitaker was like, girl, get out of here. Listen, if I get her court report, if I get anybody, the black lady right there, I'm gonna email her. Hey, send this to the judge. Give her my whole playlist. It looks like Trishelle to me. I'm happy I got it right.
All right, are we ready to turn to our potential redaction report? Should I take silence as
How about resignation?
He does keep kicking it. Don't make a ruling on it. She obviously has to catch up, but enough already. Rule on the mystery.
set? And whenever Mr. Snellman joins
This is a good quote. Sometimes you can't untwist the metal from grit.
All right, so we're now going to be on page. We're now going to be on page 75, lines 10 through 78, line 1. hearsay about who shot at Woody and who shot Boo.
I'm just muting really quick so I'm not competing, but I do agree. She obviously said on the stand, like, I didn't even know what was happening. So that is fair. And to be clear, I was just raising what Love has raised and what the judge was just pointing out at the end of that. But I agree. I assume there was an assumption everybody was operating in good faith, 100%. But let me unmute.
Neglected to inform the court, I uploaded that Dropbox link for recording. So
I don't know if I still have that Dropbox link. I don't know. Can you just shoot me the link again?
yes, Your Honor.
Okay.
I try to keep the same link for the transcript, so I will resend that link. And there's one long version of the video, and there's a smaller one where it breaks it into
Okay.
smaller chunks. I've used VLC to operate. I don't know if the court has that player on your system.
I think so. I think we have that one.
I will resend that, Your Honor, right now.
All right, great. Thank you. Okay, so let me,
I recommend that you send smaller chunks, so the bigger chunks have a harder time.
actually sending, yeah. All right, and is this hearsay?
So, Judge, what did you,
So we're at 75 line 10 through whatever the next thing is, 70, where are we? 78 line 1.
So I don't have any objection to 75 line 10, where Dennis says, what'd you hear about them when they tried to shoot Woody? All the way down to line 17, no objection to that part. But when Quindarius Zachary starts talking about, when he says, oh, you talking about where they got shot at, and then Dennis clarifies when they made this post the following day, Zachary says that's when their spot got shot up. That was the next day though, you're right.
A little bit of context if you're just joining in or trying to understand what they're doing and why I'm okay with muting right now, because when it's important information, I won't mute. But the witness that is supposed to be next, whatever happens with Woody, the person who is projected to be next on the witness stand is a co-defendant named Quindarius Zachary. He, I believe, took a plea deal though. And so he is the next witness. And so they are going through some police interviews some interviews that he had with police in which the state are trying to get in. Okay. They want to have brought in, should he get on the stand and say, I don't remember, or say, I ain't say that. They are trying to figure out from the police statements what would be allowed to be played. The defense is saying, basically, this is like a very brief synopsis. The defense is saying, basically, everything he told police was hearsay. He didn't have firsthand knowledge, essentially. And so they are going through, and the judge is ruling on what could be allowed in that the state could play or what would not be allowed in. So that is the exercise that they are going through. It is all theoretical and hypothetical because it hasn't happened yet. We don't know what Quindarius Zachary will say. But in the event he does say it, the judge said, I like to predict. In the event he does, let's figure out what I'm telling you you can play or what you cannot play. Yes, this should have been done with Glanville a long time ago, pre-trial. No, he didn't do it. And that's why they're doing it right now.
I mean, they're like saying, okay, what is it we're talking about now?
So, Judge.
Yeah.
Big Boo is someone who's deceased. But, sorry. Big Boo is someone who is deceased, but what they're talking about him getting shot at, that was not what killed him, to my understanding. But this is all just nothing that Mr. Zachary, to my understanding, has any firsthand knowledge of. And then they talk about Woody getting shot at when he went to a hotel party. That case was never charged. I've never seen anyone say they know who shot at him, and this is just more speculation and hearsay. I have no reason to believe that Mr. Zachary was at that party. And then,
I withdraw the objection. I'll stipulate.
Okay, so that carries us through all of 76 or
then
down through more, it looks like.
well, then they
Through
start.
78 line 1.
Okay, all of it.
Yeah.
Okay. Thank you. So that entirety of what is represented by our number 20 is redacted by agreement. All right, 21, that's page 79, line 14 through 22. Speculation about who shot at Thug's stepdad's house. 14. Yeah, I mean, it's pretty clearly speculation.
We don't have a problem. with
Okay,
that.
so that is out by agreement. So we pick up from there on line 23 down through 81, line 5.
And that's just, Your Honor, Tyreek, I think there's a gentleman named TJ Rivers.
Uh-huh.
I believe that's his last name. He's not charged in this case. And then Tyreek was his brother, and apparently he was killed by someone at some point.
Yeah, I mean,
has-
that all seems just like, they're kind of like, well, while we've got you in here, what might you know about any other shooting that ever occurred?
Right.
Yeah.
It has nothing to do with this case, as far as I know.
What say you, Ms. Love?
I have no objection to, I'm just gonna go down the list, the latter, page 79, 23 through 24. I have no objection to, page 80, the entirety of page 80. What do we want to do? And
I was
Up
saying Woody. I didn't realize I was
through
muted.
page 80.
They're saying 81, line 5. Let's deal with that. I mean, that all looks like,
So Slug Trontavia Stevens is a member of YSL. He's already entered a plea in this case. And Quindarius Zachary's association, knowledge of, affiliation with Trontavia Stevens. When investigator Dennis says it went quiet for a little while, and then Mr. Zachary, that is, gives this explanation.
is that supposed to say?
I can go without that. So
All right,
1 through
so-
5 I'll
Okay,
stipulate.
all right. Thank you.
If you've been watching, then you see what sometimes happens is that one side will object, and then after like digging into it, the other side or that side will be like, actually, I withdraw. Like, that's not a big deal. It can be left in. Or I want this in and I don't want it. Like, if you've been watching, you see how that happens all the time. And it's just a matter of, that's why she keeps saying, like, can y'all basically talk amongst yourself, figure that out, so you only come to me with the actual issues and not stuff that you are eventually just going to say it's fine and you're going to withdraw your objection. And so anyway, it's just hilarious because that has happened on both sides. You'll see sometimes the state has withdrawn their objections, and sometimes the defense, particularly Max Shark, because he's the one who's doing most of this, but he has withdrawn some. But when they're not talking to each other, They're not really they're not accomplishing much. So she's trying to have them kind of, they're doing that right now. They're going through stuff.
About ballistics and this matching this. I mean, if it's relevant, that information obviously can come in if it's relevant and you know, fulfills all the other requirements, but that would come in through a GBI expert matching ballistics, not through
Yeah,
investigator Dennis sharing information with Mr. Zachary.
yeah. Okay, so Ms. Love?
I have, if it is, and Judge, I apologize, Mr. Atkins just apprised me our server's down, so he wanted to get my external drive to share those,
Okay.
videos with you.
All right.
So I was.
That's okay. So we're talking about 81 line 13 through 82 line 3 and
No objection to the rest of 81. So from line 13 down, no objection to that. So 13 to 23.
No, yeah, through 82 line 3.
No objection.
Okay. Thank you. All right. Now we are looking at 83 line 18 through 84 line 21.
That's already been agreed to.
Oh, perfect. Okay. We're looking at 88 lines 1 through 13.
So, Your Honor, let me be clear. This is my understanding. Mr. Zachary, after I read this and then I've since read his other statement. I reviewed them both. I should
Right.
say. I've read them before, but I was unclear if Mr. Zachary was claiming to have been present at the club compound incident. After reading the first in time, second in that I reviewed statement, it's clear to me that he does claim to have been at compound.
Okay.
My understanding, but there seems to be a blending of what he saw versus what he was told, because my understanding is at some point he flees from the area. He is definitely, by his own words, not on 285 when Lil Wayne's bus is shot. So he can testify, or he has firsthand knowledge, presumably, about things he saw while he was there. But when he says Pee Wee ain't do the shooting, he wasn't there for the shooting. And when he says, I know who left and went behind it though, and he says DK and Shannon. So he's saying Walter Murphy, who's entered a plea deal, my client, went behind Pee Wee's car, Jimmy Winfrey's car. So to the extent that he has firsthand knowledge of things, I concede that he can testify to what he saw, and anything he has firsthand knowledge of that is inconsistent, if he had in fact had firsthand knowledge, he can be impeached. But there's certain things that he speculates, or maybe someone told him, I don't know, but it's not clear to me. So Pee Wee didn't do the shooting. That's a conclusion. He did not witness the shooting. He did not witness anyone do the shooting. So I think that's inappropriate.
Okay. So that is 88 lines 1 through 3, basically. And even the police are like, yeah, we know he didn't do the shooting. So.
Well, people in Cobb County would be interested in that, but.
Okay. Well, I don't know. I mean, maybe they're just saying that to see what he's going to say.
But then he says, I don't know who was exactly in the car. I know who left out and went behind it though.
Yeah.
So to the extent that if he witnessed a cars
Right.
leave compound, I get it.
Right.
But beyond that, things that he did not witness, that's what I'm
I
objecting.
understand. So I'm trying to kind of take it piece by piece because you're saying he cannot say with certainty Pee Wee did not do it unless Pee Wee was with him at the time.
Amongst themselves.
Okay. Do you have any basis for?
Well, the portion of it where, so Mr. Zachary, like Mr. Copeland, makes assertions about the shooting itself and who was doing what. And the way that the shooting happened is a person is driving down the road next to a bus. And in order to be able to both drive the car and shoot the bus, from the way that both vehicles are positioned, you literally have to have one hand on the wheel, and it was a precarious kind of circumstance that would be needed for the driver of the car, who is Mr. Winfrey, to also be able to at the same time fire the gun and shoot the bus. So in as much as it reflects his personal knowledge of all the people who were there and what was going on, we would argue that his assertion that Pee Wee didn't do the shooting would be subject to a foundation that, you know, we would seek to lay, and I can't say that we have laid that part yet. I think that he is just saying he didn't do the shooting. He was a party to the crime, but he didn't do it. He was driving. He couldn't have. But
So is Mr. Zachary in a second car that's involved in this?
so he is in another car, but he's not shooting. He's not in that.
He's not in the shooter car, but he says, you know, me and these other people went the other way. So he's
compound.
right.
Everybody shows up at this one place where
Yep.
the plane is in about 5, 6 different cars.
Okay.
And 2 of them at least follow the tour bus.
Okay.
He is not in one of the ones that follow the tour
Okay.
bus.
But he's there when you have reason to, you have evidence that will support that he was there to be able to say at least that as to the car that wasn't, as to some car, the car that went behind it,
And
that he saw who was in those cars?
yes, he
Okay.
says, Mr. Zachary says, I know who left out and went behind the car. So he
Yeah.
says, and the fact that he's asserting Buchanan Shannon, if he's crossed on that, I would argue that goes, it's way not as admissibility of Mr. Sharp.
Okay, but yes, and thank you. But I guess what I'm at, or what I'm trying to get clarification on is Mr. Zachary, it sounds like from what he's saying is he's there when everybody kind of goes in whatever direction they're going. And you're saying that that's his basis of knowledge for who's in what car, right?
Yes.
Okay.
Even at the point where, like in line 14 of page 88, he's saying, me and Trontavious, we don't went the other
Right.
way. Yes.
It sounds like that's all kind of contemporaneous that they're leaving out. Okay, so then I get that there is a basis on which to believe that he has firsthand knowledge to be able to say, I know who left out and went behind it. Who was that? Well, here's who it was. But coming back to the Pee Wee ain't done the shooting, if that's something you want in, then how does he know that? What's your basis for him being able to say that?
At this time, I wouldn't even proffer it. So I would agree to it unless something is said that changes.
Okay.
Because I don't have, there's never been a time where I heard him say, you know.
Okay, so then by agreement then,
Just
Well, then why do we need 2 and 3 and 4? Because they're just confusing without line 1, right? So 1 through 4 are out by agreement. So then 5 through 13, well, 5 through, how about,
So, but 5,
how about that? I mean, the 5 through 9, I see as kind of a one little answer that he seems to be able to know. They say truth was with them. What, and then what about that part?
I don't mind 12 through 13 coming out.
Okay. Okay.
So we're at, the next one is 90, page 90, 11, page 90, line 11 through 90, line 14.
Correct.
Those are words of the police.
Oh, Mr. Melnick is here now. So he's not here on the Zoom, virtually here. Do y'all all have the Zoom link? I mean, you're welcome.
No.
I see it'll show up on, does it show up on that?
Here we
big screen?
go.
All right, so y'all can just watch it on the big screen.
Are you ready for me?
I am. I think I say yes, and yet I think I need to probably turn my camera on. There we go.
Here we go. Oh shoot. I wonder if I should be on one camera. Sometimes there. Lock.
Hi, Mr. Melnick.
Good afternoon, Judge.
We can't get enough of you. All right, so the reason I have asked again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland. And he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again, whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, you know, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing that you have in fact already advised him of all of those things?
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person? If we can have him here in person, that way, if he does have questions as anything's going along, and we're not going to take testimony. I just want to find out tomorrow, does he have any questions? Make sure we clear up a few things and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor.
He should be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. So do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
And Your Honor, before he's brought in,
Yeah.
I would object to him being asked at this, I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so that he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom.
Mm-hmm.
And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just you.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have
When do you propose I ask him? Because if you're, I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that he has, are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed.
Okay. All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, essentially. So that's going to have to be in open court in front of everybody. So if that's your objection,
It was just the timing of it.
so would you rather I do it Friday? I mean, I don't understand what it is you want me to do.
It was a preference, but I'm going to, of course, defer to the court. It's just, as I work through everything that I know has taken place, I'm just trying to make certain that the interests of everybody are protected.
Okay.
I'm not trying to create a.
No, I understand. And I mean, I'm just not sure what else. I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have
Why aren't you asking about court?
anything they want to make sure I make clear with him?
I'm confused.
Not for me, Judge.
Okay. So Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed
Okay.
it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter, because what is protecting him, should he testify to something that he did that's criminal, is not whether a statute has run or not anyway. It's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay. All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And I my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. All right.
Melnick said,
Okay.
"Get out the way."
Is there a screen where he can actually see Mr. Melnick over there somewhere? Okay, thank you. All right. Let's go ahead and get Mr. Copeland in.
I am confused, I'll be honest. Up until now, it seemed like they wanted to ask him about if he felt coerced, and that it just seems like she's about moving forward, and instead is focusing this on things that were misrepresented in the ex parte. She now wants to properly represent and then see if he plans on testifying or going to jail, basically.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify, because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah,
Yes.
that one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is.
So I ain't got to wait
accurate.
till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which may be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions?
Mm-mm.
Okay. And do you want to talk to Mr. Melnick anymore about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them, we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice, whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
you can,
I
yeah,
have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied and lied and
I
lied.
know. And
So how are they gonna be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
They said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind, don't do
Can I
that.
give you an example for what they told me?
Yeah, yes, and then I'll see whether that's what I think or not, yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies. She
Okay,
said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth, okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, Immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't have
formally call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word, I am not getting on the stand?
It depends on how I wake up.
Okay, all right, well then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now. All right, Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right, thank you. Appreciate it.
He is pissed. Woody is mad. She didn't ask about that second thing that he said either.
All right, so there we have our answer to the extent we have an answer. We will revisit this on Monday morning, which is, by the way, when I plan to have the jury back. And we at least, I have some degree of confidence that he understands what his choices are and what his consequences are. Okay, back to Mr. Zachary's testimony. Everybody good? I mean, I know we just took a break. Anybody need a break before we dive back in again? Yes, all right. I didn't take a break before, so I could use one now. Let's take 10 minutes. Be back at 5 after 3.
Mm. 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 See, I'm back on. She not doing a mistrial. She hasn't ruled yet. I think I saw somebody asking. She hasn't ruled yet, but I find it surprising that the second thing he said was he asked about the perjury, I think, but then he said specifically about the Donovan Thomas thing, and she didn't key in on that. Maybe her explanation was to address both, but she didn't key in on that. And the second thing is, I literally thought, and I thought that had been a part of the discussion. Yvonne, I see you. I'll make a poll. But if about the coercion, I mean, I'm a little surprised none of the defense said anything. So maybe I'm wrong, because if all of those attorneys in there who are actually attorneys, and I'm not a lawyer, but I'm thinking about maybe I got mixed up at some point because that is surprising to me. But okay. Okay. I mean, but also I guess his credibility, right? Like, do you want to ask him how credible is he to ask a question? I don't really know. We can take a poll. Oh, I just put that in there. I added that as the last one. Yes, we're still live. Define testify. Is he going to get on the stand and not say, I plead the fifth? And this again, this is here's my question. Here's what plays out in my mind. We have this testimony already of Woody. We have his testimony and we have the police interviews that have been played already. Judge is going to say, let's say Woody comes Monday and he says, plead the fifth, not testifying, take me to jail. Let's say he does that. So then she instructs the jury, because if he does that, then technically none of his testimony should have been admitted. So then she tells the jury, wipe everything he said out. You have to, it's stricken from the record. We're taking your notes. So now the jury in that scenario never hears from Woody again. They only have heard what they have heard from him and the tapes that have been played for him, which they've been told to forget and never think about again. And they never hear from him again. I would be filing another motion for a mistrial, because that means the prosecutors, the defense attorneys never got to cross-examine him. And yeah, it's stricken, but again, you got a fair trial. You got to think about what's fair. That is not fair. If that were to happen, that's not fair. I would be fighting. Yeah. Okay, so what are y'all saying? What is the poll saying? 58%, 57, depends on how you wake up. Yeah, no, he can, but he can't plead. If he pleads the fifth, he's going to jail. He still can. That's essentially what she was just asking him. Are you gonna essentially say no? Are you not gonna testify and then go to jail? So pleading the fifth. And if that happens, then she would tell them to, well, regardless, she's going to be telling them to forget his previous testimony. What I'm saying, the difference is she's going to tell them forget his previous testimony. And then he could get up and essentially retestify. But if he pleads the fifth, she's going to tell them forget his previous testimony. And then they just never hear from him again. Those are the differences. If he were to go to jail and then there's a mistrial, that would technically be the end of this trial. So I would imagine he gets out of jail. I'm not a lawyer, and I didn't look up the case law like Mr. Matthews Sr. did. But what with the case law supported that it would go to the end of this trial. So if it is the end of this trial, I would imagine he gets out until they retry. I could be wrong. That's what I would imagine. What is that? Pizza? Oh, I'm okay. I maybe immunity takes the option of pleading the fifth away, which means if you plead the fifth when you have immunity, you go to jail. That's what I'm saying. He can plead the fifth and go to jail. That's the option. That's exactly what happened the first time. That is the consequence of having immunity and pleading the fifth. You just go to jail. And so that's what she was asking. Are you gonna go to jail till next year? Is that what you willing to bear? Or are you gonna get on the stand and testify? And so he's saying, we'll see how I wake up. Okay, so y'all are saying he's gonna testify, but he's gonna give them the runaround to avoid jail. He got motion right now. He don't want to go in. That's, I mean, it's not a bad point. He out here making moves, probably making money. And so you go to jail and now you lose all of that. So you can stay out, say, I don't recall, I don't remember. And then this exercise that the attorneys and the judge has been doing of going through his statements to determine what is allowed in and what's not, they just go to those. It could happen. You know what? One of the things he said though in one of his maybe it wasn't, I don't remember if it was one of the police interviews, but he was talking about going to jail is dangerous, essentially. Like it is scary to be in jail as well. So it's gonna be like we gonna see how he wake up, what he actually is going to decide to do. It sucks. It is a tough situation to be in my opinion. Yeah. So he can get up there and I don't recall the whole thing. But I mean, somebody said, if I was a judge, what would you do? For me, this comes down to fairness. And I think harm has been done. Errors have been made that are harmful to the defendants. I think this place that we are in makes this no longer a fair trial. And I'm not a lawyer or a judge, but it feels unfair for him to be one of their star key witnesses and not like your amazing star, but like your testimony is so important for our case star, for his testimony to be so, that's why I think Attorney Love was freaking out. I think Attorney Love was actually freaking out at the fact that, oh my gosh, he could actually choose to not testify. And what are we going to do if that happens? Because it's less about him on the stand and more about the statements that he made to police years ago that she needs to get in. He could get up there and say, I don't recall, which is great because all she really wants to do anyway is play the tape. So, yes, a couple of people are saying it, but substantial errors, yeah. Irreversible error, 100%. It's all those. I feel like it's no longer fair, but you know. And the other thing, and this is why I think coercion for that ex parte is so important and interesting, because if he in there saying, I can own up to all of this, I can say essentially I killed Donovan Thomas, like if he is willing to own that, and she's like, that's the thing we're going to prosecute you on, that you say that and you're going to go to jail. I don't understand how that is not coercion, how that is not me bending the law and making it such so that you will testify for me. Like, I just don't get it. I just jumped to the end because it just zoomed up. But yes, we are still waiting on the mistrial decision. That has not been made. It has not been made. And now she gave Love until Friday, but she's talking about we're going to have the jury back on Monday. So is she going to issue the order on Saturday or Sunday? Which to me, again, is giving we're pressing on. I'm just not convinced that she is going to end this. I'm not convinced. He would have to, what does he need to say for her to not play the video? He would essentially have to say what he said before, because what it comes down to is prior inconsistent statement, impeachment, right? Like that's what it comes down to. So If you say something different than you said before, I get to play what you said before to show that you said something different before. So, or let me show that you're a liar, because now you're saying, if he were to say, no, that didn't happen, and I have video of you saying, yes, it did happen, right? So he would have to say what he said before. Yeah, they are going to be able to ask him everything after the 12th wiped out. So, I mean, in La La Land, it never happened. Men in black glasses, we are flashing you out. It never happened. So they get to ask him the same things. You know what? Weinstein isn't in trial today. He's not there. There's somebody else. I low-key want to tweet him to be like, where you at? I am curious what she's waiting on. I mean, it is a lot to think about and consider, but are we past the time? What time did she say? It's a lot of record that she has to catch up on. I hope that is what a lot more is happening, but I hope that she is really catching up on stuff that has already happened, because I think all of that needs to weigh in her decision. It's unfair to have limited, background as to what has happened. Like, all of that needs to weigh in, because it's not maybe it is an isolated event. I don't know. But I don't know. I don't know what could be taking her forever. I do want her to rule, though.
Okay.
Yes. And new questions, old and new. They don't have to stick to the exact same thing. 100%. Sorry if that was unclear.
All right, so I think we are on page 90, lines 11 through 14. Okay.
So let me end my poll.
That's law enforcement speaking, basically saying that
He could. This is a part of the civil contempt. He will be held in jail until the trial is over, or until he decided to purge himself of the contempt, which would be testifying. So he could later, I guess, say, hey, actually, I changed my mind. I'm tired of being in jail. Let me come testify. That could happen.
Page 90, line 14, I should add this. I've reviewed all these statements, and I've written notes where I feel that the transcript is insufficient. In my notes, I have on 90, line 14, Underwood, Investigator Underwood says Shannon the shooter. And then Dennis says because, and then Underwood says Shannon the shooter again.
Okay.
So that's my objection, is the police
All right.
labeling my client the shooter.
Well, the answer is good for your client.
I understand that, but I just.
But yeah. All right. What does the state say?
Your Honor, it's a question,
No.
it's not an assertion.
No.
They're asking, is Shannon the shooter? And the inflection given by any person repeating it wouldn't do as much justice as listening to it.
Well, I will happily listen to that as well. But even if line 17 is a question that is saying Shannon the shooter,
Right.
then we probably could just go with line 17 and not like the 11 through 16.
So.
What do you think?
So 11 through 13, we would object to being excluded, because that's Detective Dennis asking of Mr. Zachary something about one of the defendants currently on trial based on Mr. Zachary's relationship with him and affiliation with him. I don't have any objection to 14 through 16 coming out.
Okay.
That's what they want, but we would ask that the court I think Mr. Atkins has had an opportunity to send the link to the, no, he hasn't. He said it's taking 31 minutes.
Yikes.
So, I may be able to, I don't know if,
I mean, if y'all have it and could just pull it up, I can listen to it right now. Talk into your mic, please.
On line 21,
Yes.
Investigator Dennis, my notes say, what it says indiscernible,
Uh-huh.
says about that action.
About that action?
Yes.
Okay.
Speaking of Shannon.
Let me ask y'all, are y'all actually providing a transcript to the jury when you play these statements?
I believe we may have done it once, not with everyone, but I did intend that we clean up the ones that we have and provide a copy to the defense and see if they disagree with any
Okay.
cleanups and allow the jury to use the transcripts because they tend to prove helpful, but that we hadn't gotten to the cleanup part yet. We haven't cleaned it up entirely, and sometimes if the defense has a transcript they'd like us to use and like us to use, we welcome that as well, but right now
Okay. And I don't know if the defense would have any kind of a position on whether on that issue.
There's a lot of issues with these transcripts, a whole lot, and just in all honesty,
Okay.
Your Honor, I don't see how we could agree to a transcript without all of us just sitting in here and
Well,
going
yeah.
through with a fine tooth comb.
No, I agree. And it may come to that, but it may be, a lot of times I think when audio video is played, at least in my courtroom upstairs, there are a lot of times when it's hard to hear. It's kind of like muffly. Even if I take it in my office and listen on my computer and I can hear it crystal clear, for whatever reason, once it gets out here and gets played through, whatever, it's not as clear. Now, maybe down here in 1C, it's a better audio video system and everything's been clear. But I guess if it comes to it, we'll sort it out then. But
Judge, I can, on behalf of Mr. Williams, I can tell you at this point that we're going to object.
like I hear this voice who is talking. All right.
It's God.
Yeah.
No, I can tell you now that on behalf of Mr. Williams, we're going to object to the jury being provided any transcripts.
All right,
based on
and
everything
what-
that's happened so far.
What would the basis of your objection be?
It's been our experience thus far that we just have significant disagreement with the state on the transcripts that they're provided thus far. And we
Okay.
think, quite frankly, it's better for the jury to make their own determination about what's being said.
Okay. All right. Well, and I mean, it just may be that as we go on, if and when one day this trial wraps and a jury is deliberating, they may want to hear a whole lot over again, and we'll just all have to sit here and listen to it too. So y'all know that, and if that's what happens, that's what happens.
And Your Honor, we would also posit that there is the instruction that the court could give the jury about the transcripts not being evidence and that they are indeed supposed to listen and take what they hear versus what's written on the piece of paper as
Sure.
evidence.
Yeah, I mean, so I just was raising that to find out, had y'all already come to any kind of an agreement? What was the practice here with this trial? So it sounds like if you want to do that, first off, you need to endeavor to the extent possible to come to agreement on what a transcript says. And then second, if it's necessary, I will sort out whether I'm going to permit that or not. And I'll listen to the legal reasons for or against. But okay, so if you can tell me, I know that first thing you gave me 27 minutes, 30 seconds. So for this one, where would I be listening? Oh, we're going to play it here. Never mind.
We need the Zoom link.
Oh, it's the same one as it was a minute ago when Mr. Melnick was on.
Okay.
And for this, because the only sound appears to be coming out of those two little strange white speakers. Can y'all turn one my way? And I think that may be the subject or the reason for the squelch, but I'm not gonna be able to hear it otherwise, unless somebody wants to come up with a little speaker that I can have up here with me.
Judge, could the court give me just a minute? I'm trying to get it open and then
Yeah.
trying to get to that point.
Okay. And as long as we're gonna do this, we might as well listen to both of the ones, and I don't care which order we do it in, but.
So they are, again, preparing to play some recordings because they are working through what will be admissible and what won't be. Just FYI, that is what's happening. Are we not even going to hear it? I have to still finish editing because I keep stopping to play this. So I am probably going to get myself off the screen so that I can edit. So I can post recaps, and I got to post Woody today. But I don't imagine there will be a ton more exciting things happening today. They are going to continue going. This is the kind of stuff that should have happened pre-trial. They're going to go through witness statements to determine what should be admissible and what shouldn't be. What is hearsay, what's not. Literally line by line. That's what they've been doing. What time is it? I'm gonna give myself like 10 minutes. I'm warning you guys now. This is your heads up. First of all, thank you for joining. We was in here strong today. I am about to leave y'all. I'm gonna give it a couple minutes. So if y'all, start finding another stream, if that's what you do.
Y'all can go ahead. I mean, look, is the video matched up with the audio when y'all are showing video in court, or is there a lag?
Sometimes there's a lag if we use a server, but if we do it from a hard.
Yeah, I'm going to finish my statement. So that's all they're going to do is be going through the statements. It won't be probably a ton more. We know Woody will be back on Monday. I am going to finally finish this recap so I can post it. And then I will start on today's recap, which will be very minimal because it's just going to be about Woody. I'm not talking about all this other stuff. Anyway, thank y'all for joining. Appreciate you. I know I'm doing a full on closing, Sylvia. Join the Patreon if you're not in there. We have a good time. I just put the Kehlani docs from the father of her daughter saying she's in a cult. I just posted those in there. I'll try to make a video at some point. But if you're in the Patreon, you get that kind of stuff early. You get it first. So join the Patreon, subscribe if you haven't, liked, do all the things. Appreciate y'all. Go support somebody else's stream who's streaming this all day so I can work on my recap. Okay, bye. Just leave us. I'm leaving. All right, bye. I said I was going to give y'all 10 minutes, but now I'm like, I'm going to do it now. Katna Williams is probably streaming. She's dope.